Whenever Dwayne is ready to go.
On.
You ready, Dwayne? Gina, you ready? Correct. Yeah.
Well, here we go again.
If it's a tie, it's going to be rock, paper, scissors.
All right, I'm going to open up the hearing. Secretary with the purpose, please.
All right, application is hereby made for public hearing for the Easton, excuse me, Easton Zoning Hearing Board for property known as 0 Wood Avenue Zoning District Adaptive Reuse Block Class A. Special exception, zoning code 298-13A2, proposed alter/relocate water calls in the floodplain. Required a special exception, 298-13A6, proposed roadway and retention basin in the floodplain, requirement, a special exception. The above action is request to proceed with construction of a warehouse. The appellant is Donald Haas at 667 Exton Commons, Exton, PA 19341. The owner is Abruzzi Trust at 848 North Rainbow Boulevard, Las Vegas, Nevada 89107. One adjacent property owner was notified and it was published in the press.
Thank you, gentlemen.
Hold on.
Oh, sorry.
The resolution from the Easton Planning Commission, August 6th, is now therefore be resolved that the Easton Planning Commission recommends to the Easton Zoning Hearing Board that the request for a special exception be denied for the relocation of the water cause, the retention basin, and the road within the floodplain for the following reasons. 1, failure to meet all the application requirements under 298-14 and stamped engineered plans. 2, the proposed use is not suitable to the site per the special exception criteria, with moving a stream is not suitable for a FEMA map floodplain, which is to remain unopened and unprovoked. 3, per 298-14A4, the items presented are not legibly drawn or suitable scale to be able to sufficiently understand the detail of engineering drawings, and there is a lack of completeness concerning flood depths, pressures, velocities, impact, and uplifts, portions of factors associated with the base flood. 4, per 298-14A13, the development of a bridge which could be impacted by a base flood. 5, lack of provided items beyond the permits is evidence that these improvements are not suitable for the site.
All right, thank you. Bob, do you want to swear him in now, or you want to wait?
Let's wait.
Okay.
Good evening, folks.
You should be on.
Good evening, folks. My name is Bob Nitschke. I still find it necessary to identify myself since after almost 35 years in this chair, I'm still just the zoning solicitor. I guess they don't know when they're going to get rid of me still. This obviously is atypical from what this board usually handles. So to start the meeting, we are going to hold a very brief executive session up here because I want to review with the board some parameters, some legal parameters, some procedural parameters, so that we can try and get this done correctly. Okay? By the way, it is nice to see, we normally have half a dozen people at most at one of these hearings. It's nice to see so many smiling faces out there. Please, let's keep it that way this evening. And with that, we're going to go into executive session. We will be with you in a few moments. Can we keep it down, please? Thank you. All right, thank you for your patience, folks. Just some administrative items to take care of. First of all, because we are human beings and these folks all have other jobs just like all of you do, we will conclude this evening's proceedings no later than 10 o'clock. If necessary, we will have to come up with and schedule another date to continue the hearing so that we get everything in. Secondly, we are going to be putting 2 sign-up sheets on the table here. The first one is marked legal counsel, name and address on the left-hand side, party representing, name and address on the right-hand side. This is for attorneys who are here in a representative capacity, and they are representing clients who they wish to be considered parties to the proceeding. The second is entitled Desiring Party Status, Unrepresented, Name and Address. So if you wish to question any of the witnesses, if you wish to make comments, if you wish to speak at all, 2 things. Number 1, we're going to swear everybody en masse so that when you're asked to stand to be sworn, please, if you want to testify or ask questions or make a comment, please stand to be sworn. But as soon as I'm done running my mouth, we're going to ask everybody to come up and sign one of these 2 sheets. That is to say, if you want to be considered a party and if you want a copy of the board's decision. In that regard, I have advised the board that in this circumstance, we're going to try to be as liberal as possible in construing standing to speak. Because one of the indicia that is to be met is to show that there is no adverse effect to the community. And you're all members of the community. Now, that's not to say that the board is going to grant standing to everyone. And just so you know, you would, each of you who wants to speak ultimately, and this is after the appellant presents their case in chief, each of you will be subject to cross-examination as to your interest in the matter and your potential standing. So you may be asked questions by one attorney or another. Please be courteous, okay? That said, though the board will be liberal in granting party status, understand that we are here to hear a request for two specific forms of relief. We are here on a special exception request to alter or relocate a watercourse in the floodplain, and we're here on a special exception request for a roadway and retention basin in the floodplain and nothing else. I know this is an issue that evokes a lot of thoughts and feelings, but understand that the board is confined to follow the law, and the law dictates that we can only consider these two special exceptions this evening. So, in your questioning, in your comments, in your statements, please make sure they are germane to one of those two issues, because even though the law says, both under our ordinance and under the municipality's planning code, that formal rules of evidence do not apply to a zoning hearing board, the board can exclude evidence which does not have anything to do with why we're here, and can also and will also exclude evidence which is repetitive. So again, I know everybody may want to get up and say their piece. Please, if someone has already made the point that you have in your head, refrain from getting up and repeating it so that we can complete this in a timely manner. One final housekeeping rule. Again, I was trying to keep it a little jovial when I talked about smiling faces. Let's keep it that way. Please remember that these are all your neighbors around you. Please remember that the attorneys who are here representing their respective clients are doing their jobs. Respect one another, so that when somebody's talking, please refrain from doing so. Mr. Chairman, have I missed anything?
I can't hear you.
I asked about 10 o'clock. If you
I
mentioned.
did tell, that was the
Okay.
first thing I said, yeah.
All right, very good. All right, very good.
You have 4 zoners too, so.
All right.
Yeah.
Oh,
We have 4 zoners off.
council, we do have one member missing this evening. You are familiar with the ordinance and you wish to proceed, I presume.
Yes, sir.
Okay, thank you. At this time, and it applies to anyone who is not in the room but watching remotely out in the hallway, if you want to come up, if you want to speak, ask questions, make comments, please come up and sign the sheets now. Please write legibly so that I can determine who it is I'm sending a copy of the board's decision to. Thank you. Let's do it now, please.
Everyone stand, please.
Whoever
No,
wants.
we're not swearing.
Just
We're
the ones that
signing
want.
on.
Oh, not swearing in now? Oh,
We're going to swear in a minute.
John, it's already 6:15.
Oh, yeah, just sign them up to get it. So what else is going on?
Oh, I forgot to look. Yeah, why don't we put one, Dwayne,
What else
why don't we
is
put
going
one on one side? So we
Oh,
got
yeah, that's fine.
two
We'll put the council one on
10
the other
o'clock
side.
this morning, the bus
so that
left.
Not everybody.
Four. Oh, so they left already? Yeah, they're gone.
Huh?
Rome and then home, well, into Rome and then home, they'll fly back from Palermo to Rome and back.
Got it.
Yeah, they're going to southern,
By the way, if you're signing in
down the,
and sitting in the hallway, before you go back out, please remain in here to be sworn before you go back to take your seat.
That one did, but us.
oh my gosh, it was wonderful. I loved it.
Yeah, I don't.
Yeah, so they're on the ride. My sister, she was a wreck ride. She never went anywhere. No, nowhere. But she went to Canada one time. This is her biggest grandson. And his girlfriend. Oh, they've been living together for years. I mean, I guess they're, but so they stayed at my house last night. First, they came yesterday, and then like everybody that wanted to see them came to the house. I was gone. I went to soccer, but so this morning I go upstairs. The bed's not made.
Why?
It's like what? I mean, I can make both beds. I had to straighten up my sister's room. She's like, I just don't get it. I just don't get it. I mean, they're coming back and they're going to stay. That's the last night. They're going to stay again. Well, no, just because I'm not going to strip them until they leave. So, but yeah, go upstairs and there's no bed. That's the first thing I do when I get up. Make beds. I hate to make beds. I was always that way.
Oh, I do. Blue ball.
Just really, I just like to sleep in the room. I just, but I just pull my, actually, like, pull the quilt up and put
What's that?
the pillow shams back. I mean, put the other pillows back. It
Well,
just,
I mean, years
they
ago,
do it at least make
Yeah.
we went from like a
Hopefully.
no.
not. It takes up most of our bedroom.
No.
You just have like this. You just have like this perimeter to walk around.
Do you mind if I take a picture of that?
Absolutely. Go ahead.
Karen said, oh my God,
But we, it's very common.
I did too. I don't even think I came back downstairs. I think I went up. Oh, what is it?
Do we have the facility to do that?
Oh,
Oh. I think it was a book box.
yeah.
And how are we going to
Love
do
that
that?
book box.
Unless they have it on the thumb drive. I want to leave the thumb drive here.
Well, Karen, I forgot to give it to her last night. I dug out my, because I had their paperweight, and I said, well, you can take mine
Okay.
before you go buy one. I don't use that. And you can go on the same account. Yeah, but I mean, I can also deprogram.
Public
it so
record.
She can program her stuff in too.
Everybody on time?
You just throw that one.
You know what I'm saying?
Loud enough to wake me up.
There's a way.
Has everyone signed in who wants to sign in? Okay, Mr. Chairman, if you want to call for the swear of the witnesses, please.
All right, I'm gonna have, at this time, I'm gonna have everybody, asked to stand and be sworn in, please. Who's ever speaking tonight. If you're not speaking, then don't stand.
Bob, I'd like to be sworn because I'm going to introduce a lot of documents.
You're welcome to. I don't see it as necessary, but that's fine.
Thank you.
Sure thing.
Raise your right hands, please. Do swear by mighty God, the searcher of all hearts, that the testimony that you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth, and as you shall answer to God at the last great day. Do you so swear?
Yes, I do.
Mr. Chairman, if I may have the mic back just for a few more minutes. Mr. Tillman, at my request, did you put together a narrative of how we got here this evening?
Yes, I did.
And can you make that part of the record at this time, please?
Yes. For tonight's special meeting, this is the synopsis of how we got here. The original floodplain review was completed on July 23rd, 2024. At that time, it was determined that the proposed building was not located within the floodplain and no further review was required. During the June 4th, 2025 planning meeting, it was brought to the department's attention that further review is necessary regarding the relocation/daylighting of an unnamed tributary, access road, and stormwater basin that is located in the floodplain. Upon further evaluation, it was confirmed that the relocated tributary, stormwater basin, and roadway are located within the floodplain and therefore require a special exception under the floodplain regulations in section 298.13A2 and 298.13A6. On June 7th, 2025, the applicant was notified via email that a special exception would be required. On July 8th, 2025, the applicant submitted a special exception application for the relocation of an unnamed tributary, the stormwater basin, and the roadway located within the floodplain. The application was reviewed and forwarded to the city engineer for review as per section 298.15A. On July 25th, 2025, the city engineer approved the application, noting that the proposal was consistent with the previously approved subdivision plans. On August 6, 2025, the applicant appeared before the Planning Commission for consideration of the special exception. After review, the Planning Commission voted to recommend denial of the request to the Easton Zoning Hearing Board, citing concerns with the relocation of the watercourse, the construction of the stormwater basin, and the roadway within the floodplain.
Thank you, Mr. Tillman. For the record, was the property posted?
Yes, it was.
Okay. And referring to the reasons given by the Planning Commission to support their denial or their recommendation that the board deny this, was there anything else submitted by the appellant in response to any of those reasons?
Just additional plans.
Okay, and were those plans in specific response to any of the enumerated reasons given, and did they address?
Let me see my paper.
Or counsel, are you going to cover that?
Well, I'm going to cover it, but at the Planning Commission, we submitted a binder of documents that's at least as big as this one, and testimony from a number of our consultants. So yes, we responded. Well, let me say this. We weren't told what the reasons were until after we had made our presentation.
Right.
We
And all I'm trying to ascertain for the record is there's at least an intimation that there were things missing that led to the Planning Commission's recommendation to deny. And all I'm asking is, was there anything else submitted after this?
What did we submit? We were asked to submit, I think, a whole set of plans when we had submitted copies or they were on the. Stamped engineered plans?
Yeah.
No, wait a second. We can't have like shout outs.
Yeah, just one person speak at a time, please.
My engineer's better to answer that than I am.
Would you identify yourself, sir, please?
I'm Donald Hawes with Boja Engineering.
And are you indicating that there were additional submissions in response to the reasons enumerated by the Planning Commission for recommending denial?
Correct.
And can you tell us
No, we had.
which of the 5 reasons the additional submissions were intended to address?
The stamped engineering plans was one of the reasons.
Okay, so that has now been submitted?
Correct.
And Mr. Tillman, you acknowledge that?
Yes.
Okay. Mr. Haas?
Trying my memory here a little. We also submitted additional, I want to say, clarification on the H&H report, the hydraulic and hydrology analysis report, because some of the reasons they enumerated were contained within the report that they previously did have as part of the submission. I don't think there was anything else to submit.
Okay.
And we'll get into some of their other reasons that were actually complete on the first submission.
All right, thank you.
May I suggest this? If that's relevant, I guess it is to you. We submitted to the Planning Commission a binder of 17 or 18 documents. Dwayne has a copy of that binder, and if it's relevant to this board,
No. Not what was submitted to the Planning Commission. What the Planning Commission is intimating within its resolution was not submitted. I'm trying to establish for the record if anything else came in, and if so, which of the 5 reasons for their recommendation they were intended to address. And Mr. Haas just answered that question.
let me just make it clear, Don, I believe that anything that we resubmitted had been submitted was you had submitted everything on the portal, on the city's portal, and everything was available electronically.
Okay,
There were some complaints that they couldn't read the plans because they didn't have full copies. So we said, we'll bring you full copies.
okay, thank you. And I just have one more question, just so I'm clear on what our board is being asked to determine. Reason 4 for their recommendation in the resolution says, per section 298-14-813, the development of a bridge which could be impacted by a base flood. I didn't see anything within your application that mentioned a bridge.
There is a culvert. There's a culvert across the relocated water course that serves as a bridge.
I see.
But Don specifically testified that that bridge culvert would not increase the base flood elevation.
Okay, and I'm sure we'll get into that testimony.
We
I just wanted clarification because I didn't see the word bridge anywhere in your appeal. So I just wanted to know what the board was being asked to consider tonight. Thank you. With that, I'll turn it back to you, Mr. Chairman.
All right, thank you. All right, you may call your first witness.
I have an opening statement, Mr. Chairman.
Absolutely.
So my name is Mark Kaplan. I'm with the law firm of Kaplan Stewart. We are attorneys for Eastonwood Avenue Propco, Propco, LLC, in connection with its application for a special exception approval under the sections that have been cited, 298-13, capital A, paren 2, and section 298-13, capital A, paren 6 of the City of Easton's floodplain management ordinance. I suspect that the board is familiar with this property and the development project proposed by my client, as this has been an ongoing project in the community of some significant note for at least a couple of years. The component, and I emphasize that word, the component of our client that brings us here this evening relates to the relocation of an unnamed tributary to the Bushkill Creek and the construction of certain flood control structures within the tributary, including what's been testified to, the culvert and the road. The property that is the subject of tonight's proceeding is the approximately 106 acre tract known generally as 1525 Wood Avenue in the city of Easton. There are a whole series of tax ID numbers that I'm not going to get into. Easton Wood Avenue Propco LLC is the equitable owner of the property by virtue of an agreement of sale with the Abruzzi Trust, the legal owner of the property. Copies of the tax map for the property and the letter from Abruzzi granting my client authorization to present tonight's application to the board are included in the exhibit binder, and I'm going to ask Jessica to bring them up so that everybody can see. We were criticized at the Planning Commission for not showing all of our stuff electronically, so we're going to show everything electronically so the attendees can see what we're talking about.
We're just waiting for it to connect.
Okay. I don't need one of those pregnant pauses. It was well behaved the other night.
You have a flash drive? Oh, there it goes.
There we go.
It's a little slow.
Okay, so what is on the board is Exhibit A1 in your book, and we could bring up A2. It's just a letter from the Abruzzi Trust saying that we have authority to be here. Jess, was that the tax map?
Correct, A1.
Bring it back up. So as shown on the tax map, the property is irregularly shaped parcel of land located in 3 separate municipalities. Approximately 62 acres are located in the borough of Wilson, 15 acres are located in Palmer Township, and approximately 29 acres of the property are located in the city of Easton. The historical industrial operations on the property have ceased, and the property is now mostly unimproved and somewhat overgrown and has been vacant and underutilized for several years. The property is bounded by Wood Avenue along the southern property line, and the Hackett Park Recreational Facility to the west. Wooded areas abut the property to the north, and the Bushkill Creek flows in the north-south direction along the property's eastern boundary line. And I believe that those directions are pretty evident on Exhibit A1. Everything is north of 22. Please bring up the, I was about to skip something, I'm sorry. An unnamed tributary to the Bushkill Creek traverses the property from west to east through basically an underground tunnel near the Wood Avenue frontage. It is the relocation of this tributary and the associated encroachments into the tributary's floodplain for which we are seeking the special exception. Pursuant to Easton's zoning map, a portion of which is included in your exhibit binders as Exhibit A3. Yeah, that's it. See if you can blow it up a little bit. The base owning of the property is AR adaptive reuse, and the property is also subject to the street corridor overlay district. Additionally, portions of the property are located in the special flood hazard areas as classified by the flood insurance study and the accompanying flood insurance rate maps prepared by the Federal Emergency Management Agency. A copy of the FEMA flood insurance rate maps for the property is included in the exhibit binder as A4. And that map that Jessica has up is that floodplain map. When you look a little closer, it shows you different types of zones under the floodplain regulations. And I believe there, the way she's got it, you can see where the Bushkill is and where the unnamed tributary, they run perpendicular to each other. Only approximately 72,000 square feet of the warehouse building that is proposed is to be constructed in Easton on a parcel identified as L914-4, while the remaining approximately 936,000 square feet of the warehouse building is to be constructed in the borough of Wilson. There will be no improvements in Palmer. Although there are no modifications or disturbances proposed to the Bushkill Creek that would change or affect its flow patterns, the proposed redevelopment will require relocation of the unnamed tributary and associated encroachments into the floodplain areas. Please look at Exhibit A6 to see the existing location. Okay. Yes, there's A6. Now back it up a little bit. You were good a minute ago, Jessica.
Oh.
I want to be able everybody to see the whole thing. That's it. So along the right side, obviously, is the Bushkill. From left to right is this tributary of the to the Bushkill, and Don will get into it in more detail as to what we're doing. As I said, the unnamed tributary extends underground along the property's Wood Avenue frontage for approximately 300 feet. The proposed project will relocate the unnamed tributary, place it above ground or daylight it, and require various other improvements, such as the construction of a 40-foot wide paved access road, a culvert for crossing the unnamed tributary, and the addition of various utility crossings, including a 12-inch water line, a gas main, multiple stormwater management pipes, stormwater management facilities, and stormwater outfalls. A plan depicting the proposed relocation has been marked as Exhibit A7 so that you can see what we're talking about. So it's basically taking the hump out of, or straightening, the unnamed tributary so it flows totally east to west. I'm sorry, west to east. And that's Exhibit A7 that we're showing. Now, while the project was proceeding through the land development review process within Wilson Borough and Easton, my client was also seeking the necessary approvals from third-party and outside agencies. And I think this is, what I'm going to get into now is very significant for this board to understand. In the book, there are exhibits A8 through, A8H. Try one more time. A8H A8A to A8H. And these are copies of the approvals and the permits that are relevant to the application for the special exception. I guess you could bring them up, but they're just pieces of paper, so if you can stay with me. So the first one, designated A, is the Eastern Area Joint Sewer Authority, Pennsylvania Department of Environmental Protection, Sewage Facilities Planning, a Chapter 94 consistency determination dated September 27th, 2024. That says that the Eastern Area Joint Sewer Authority and the Pennsylvania Department of Environmental Protection have approved all of the sewer planning for this project. Now, the second one, B, is also very significant because it was authored by Pannoni Associates, who is the Eastern Stormwater Management Consultant. There is a recommendation for approval of the Stormwater Management Plan, and that's dated January 14th, 2025. The third one is the Lehigh Valley Planning Commission. Under Act 67 in Pennsylvania, each area has to have a stormwater management plan for each water course in the area. The Lehigh Valley Planning Commission has been designated as the overseer of the Bushkill Creek Watershed Act 167 Stormwater Management Ordinance and issued a consistency letter on February 26, 2025. A consistency letter says, basically, that the plan that has been presented is consistent with the Act 167 Stormwater Management Plan for the Bushkill Creek. Now, the next two permits are even more germane or important to this application. D is the Pennsylvania Department of Environmental Protection's National Pollutant Discharge Elimination System, generally called a NIPDES permit or an NPDES permit. It's an individual permit. It permits the discharges of stormwater associated with our construction activities, and it is dated April 15th, 2025. In general, it is DEP's overall permitting process for stormwater management activities in Pennsylvania for anything over an acre. And this approved the plan that we submitted, including the floodplain, including the relocation. And then we get even one more specific PennDOT permit honing in on the relocation. And that's Exhibit E, or Sub E. It's the Pennsylvania Department of Environmental Protection. It's a water obstruction and encroachment issuance or permit issued on April 15th, 2025. This permit gives my client DEP's approval and authority to relocate the unnamed tributary, to do all of the encroachments in the floodplain that are on the plans. It is a permit, in essence, that approves exactly what we are asking this zoning hearing board to approve. Number F, it's Pennsylvania Department of Environmental Protection. It's the Act 537 planning module approved by DEP. This is, again, a sewer planning type module. G is the correspondence with the Northampton County Conservation District, confirming the Northampton County Conservation District's approval of our erosion and sedimentation control plan. And finally, in this aspect of our presentation, H is the conditional approval of the preliminary final development plans for the Easton Commerce Center issued by Wilson Borough on February 27, 2025. Now, after being notified by Mr. Tillman, as he said before, on about August the 27th, that we will need a special exception to reconfigure the floodplain, on July 8th, we promptly filed the application with this zoning hearing board. A copy of that special exception application filed on June 8th, 2025 is included in the exhibit binder as Exhibit 9. And I'd like you to just take 1 second and go to Exhibit 9 and just take a look how comprehensive that application is. It's almost 3/4 of a page thick. It supplies every bit of information requested by the ordinance and approved by the city, and includes with it 2 things that are required by the ordinance in order for us to get a special exception. The aforementioned NIFTY's permit and the aforementioned water obstruction permit. Your ordinance says that before we can get this special exception, we have to get DEP's blessing, and we have done that. I think I've gone through this return, A, D, and E. We covered D and E. They were the water obstruction permit. And, okay, let's go to, I do want to point something out. Let's go to 8AD, please. NIFTY's permit, maybe I got the wrong number here. Oh,
That's
it's E. Please look at the first page, the NIFTY's permit, and I want to read a part of it. Under the authority of the Federal Clean Water Act and Pennsylvania's Clean Streams Law, the Department of Environmental Protection approves your application for a new industrial NPDES permit for discharges of stormwater associated with construction activities. Your permit is enclosed. The latest version of the permit application and all supporting documents, including the erosion and sedimentation control plan and the post-construction stormwater management plan, are incorporated into this approval, including the following drawings, and then there's a long list of those permits. Now, I'd like you to turn to the 3rd page of the water obstruction permit. The water obstruction permit is F. So when you get through the first paragraph where it spells out all of DEP's authorities under various acts, says which empowers the department to exercise certain powers and perform certain duties by law vested in and imposed upon the Water Supply Commission of Pennsylvania and the Water and Power Resources Board hereby issues this permit to my client. And then right in the middle, it says, giving its consent to construct and maintain the following water obstructions and encroachments associated with the Eastern Commerce Center. And then there's the long list of permits that Mr. Tillman relayed to, but these are all of the various permits for what we're here for tonight, the relocation of the floodplain or the water course in the floodplain of the unnamed tributary. So, Mr. Solicitor, I had submitted an extensive pre-hearing memorandum to you and the board laying out our opinion of the law. And I assume that the board has seen that?
They have not.
They have not. Okay, well, I don't want to give a long dissertation on the law. I'm sure that you'll instruct them. But there are a couple of key things. I think you probably know this. Under the law, a special exception is not an exception to the ordinance, and it's not a variance. Instead, a special exception is a use to which an applicant is entitled if the applicant proves that such use complies with, and I emphasize these words, specific criteria of the particular ordinance. An applicant who satisfies this burden of proof is entitled to approval unless objectors offer credible and probative evidence, and this is a very, very high standard, to a high degree of probability that the proposed use would have an adverse impact on the community in a way not normally expected from such use, and that such adverse impact presents a hazard to public health, safety, and welfare. The objective criteria applicable in a special exception for which we are seeking your approval is contained in Article 5, Section 298.10 and Section 298.13b and Article 8 of the Flood Management Ordinance. We are here tonight to demonstrate that the special exception application that we have filed complies with the specific objective criteria applicable to the proposed relocation. Section 298.13 of the Floodplain Ordinance requires approval from the Pennsylvania Department of Environmental Protection before any floodplain encroachments are permitted. The PADP NIPDES permit and water obstruction permit are the permits that we were required to obtain from DEP. It is my opinion, at least I believe it, that since my client has already obtained those approvals, it has already demonstrated compliance with the applicable requirements of the Floodplain Management Ordinance and is entitled to the special exception unless objectors can present credible evidence to such a high degree of proof that it proves that well, I gave you the words before, and I won't repeat it. For the solicitor's edification, we've included as Exhibit A10, the Commonwealth Court's decision in Williams Holding Group versus the Board of Supervisors of West Hanover Township, the 2014 decision. I'll save some time and not read the exact quote that's there, but that case basically says that when you're in this situation where for a special exception, you've got to prove that your flood encroachments or relocations are proper. You've got to give an awful lot of weight to the findings of DEP. So, therefore, it is our position that the extensive review process undertaken by my client and its professionals in obtaining the approval of DEP to permit the channel relocation and floodplain encroachments, together with the maps, the plans, all the material that we're going to send, more than satisfy my client's burden. This position is shared by Easton's planning staff, as indicated in their recommendation for special exception approval issued on July 29, 2025, and it's Exhibit A11, and I'd like to highlight some words from that document also. If you would go to the last page. The zoning administrator has determined no variances are required with this application. The special exception criteria, and then he lays it out. And then the staff recommendation. The issuance of permits by DEP and the Army Corps of Engineers is sufficient to demonstrate that the applicant has complied with all requirements of the proposed special exception improvements for the relocation of the water course, the retention basin, and access improvements, as these permits require a demonstration to federal and state authorities that the proposed improvements will be accomplished with minimal detrimental impact. Therefore, staff recommends that the Planning Commission make a recommendation to the Zoning Hearing Board for granting the special exception requests of my client for the relocation of the existing tributary that will daylight into the Bushkill Creek, the retention of the basin, and the 40-foot wide access. That's my rather long introduction. I apologize if it was too long, but you heard what we were criticized for in those reasons for recommending that we be rejected. And it was very important to us that you see very clearly what we have done to obtain this permit. And I have with me two witnesses tonight. One is Don Haas, who's our landscape architect, who has prepared all of the plans, and we will take you through the plans. And then I have Jeff. What's the matter with me? Jeff Smith. How could I forget Smith? I apologize. Is a senior environmental engineer of extraordinary experience. And he has been the person that has marshaled the property through the Pennsylvania Act 2 process. And rather than me telling you about it, Jeff will tell you about what that process is. So,
Counsel, but before you call your witness, I just want to address what appeared to be your argument that your client is entitled to the requested relief based on your presentation. I think I respectfully disagree. You yourself said, did you not, that obtaining those various and sundry permits were a precedent to obtaining planning commission and zoning approval, correct?
they are a precedent to under the ordinance. That's
So
correct.
is it your position then that obtaining those permits excuses your client from meeting the requirements of the zoning ordinance and in particular the FMO?
No,
No, it's not. Okay.
it's not my position, and if that were my position, I would say I rest my case. I have those permits.
Then I misunderstood.
No, I understand.
Okay.
I do, let me get back to one piece that I didn't read that I think explains, this is from the Williams Group case. It's not that long. Developers submitted the permit approvals granted by DEP and COE, the Corps of Engineers. As suggested by the developer, those permits require a demonstration to federal and state authorities that the proposed construction will be accomplished with, and listen to this words, minimal detrimental impact, which is basically the requirement, the overall requirement of your ordinance. The approval thus provided some evidence that the construction would have the least harmful impact on the protected stream bed area. Furthermore, developer offered the testimony of its engineering expert, Bob Fisher, who testified with regard to the process of developing the stormwater facilities plan for the purposes of DEP, Army Corps, and township review approvals. The evidence relating to DEP's and Army Corps' review and approval, and Mr. Fisher's testimony concerning developers' efforts to avoid an impact on one of the properties constitutes evidence, and this is what I was getting at, that supports developers' assertion that the proposal would be minimally invasive, and the evidence was sufficient to satisfy developers' initial burden. And the burden then shifted to the objectors to demonstrate, and I've already laid out that 2 sentences of how high their evidentiary proof is.
Okay.
So I hope that squares it away.
Right, but you do acknowledge that notwithstanding that you have all of these other approvals and permits before you came here tonight, you still have to establish compliance with the requirements of Easton's FMO.
Absolutely.
Okay.
We could have a theoretical discussion of whether or not those requirements are coterminous or whether Easton's got something else, but
I just
I'd
wanted to
rather
make
put-
sure we were on the same
we are.
page.
We are.
Okay.
We
All right.
are.
Thank you, counsel.
Okay. So let me call Mr. Hawes. And we are going to try during this application for Jessica to control the audio-visual so that we can tie Don's testimony to at least the plans that are included.
Let me interrupt one more time because I'm not used to having an attorney give sworn testimony. So in this instance you have, there are attorneys who are present. Is there anyone who has any questions of counsel with respect to his presentation? Phew. Proceed.
I was gonna say bring it on, but I keep my mouth shut. Try to. Thank you. All right, tell us who you are.
Good evening. I'm Donald Hawes with Boja Engineering.
And give us your business address.
My address is 667 Exton Commons, Exton, PA.
Jess, would you bring up, oh, you've already brought it up, Exhibit A12. Don, is that a copy of your curriculum vitae dealing with your educational and professional qualifications?
Yes, it is.
And is that document accurate?
Yes.
Okay. Let's go a little bit farther. Can you briefly describe your educational background, the degrees you have obtained, and your experience?
So I've worked in the landscape development process for over 20 years. I'm a licensed landscape architect in Pennsylvania and Maryland. Along with that, I have various certifications for project management, stormwater quality,
I'm going to ask you to slow down a little bit.
and some other related items for when I have to do my continuing education. My continuing education is focused on stream restoration specifically.
And I don't know that you said your educational background.
Graduated from Drexel University with a digital media bachelor's and an architecture minor.
And again, who are you employed by?
Boja Engineering as a branch manager.
Now, what are your general responsibilities with Boja?
Branch management is managing everything that comes in and out the door, and project management specifically for individual projects such as this.
And are site design and preparation of land development plans, such as those we will be reviewing this evening, an essential part of your professional responsibilities?
It is almost the entirety of my responsibilities.
And as part of that, do you regularly read, interpret, and apply municipal, state, and federal permit regulations?
Yes, daily.
And as part of that experience, are you also involved in what we call the outside agency permitting and approval process in Pennsylvania?
Yes.
And that primarily involves what?
DEP approvals for any site disturbance over an acre, conservation district approval for any site disturbance over 5,000 square feet, PennDOT approval for any time we have a project that connects to a state road.
Does that experience include interfacing and communicating with third-party agencies such as PennDOT, Pennsylvania Department of Environmental Protection, and the U.S. Army Corps of Engineers?
Yes, it does, regularly.
Wait, yes, it does what?
Regularly.
And am I correct that you prepared the plans for the Eastern Commerce Center that we will be reviewing tonight?
Correct.
And are you generally familiar with the Eastern Floodplain Management Ordinance as it applies to this project?
Yes, I am.
Mr. Solicitor Voidier.
I have none. Any representative counsel? Would you identify yourself for the record and who you're representing?
Yes, Edward Shaughnessy here for Katrin Hoyne and Dennis.
Second, Shaughnessy, I can't hear you, that's speaking in the
Ah.
microphone.
Edward Shaughnessy here for Dennis Lieb and Katrin Hoyne.
I'm sorry, I didn't get the second name.
Sure, it's spelled Huynh.
And the first name?
Catrian, Catrian.
Thank you.
Yes, Mr. Haas, first of all, are you a physical engineer?
No,
Do you have any kind of engineering degree or licensure?
no,
Are you familiar, did you participate in the post-construction stormwater management report?
yes,
Did you participate in the hydrology and hydraulics report?
yes.
Do you know what methodologies were used to estimate the flow rates in those reports?
Off the top of my head, I do not.
Do you know what soil classifications were used in the development of those reports?
Off the top of my head, I do not. It's a very specific item.
Was there any consideration given to low-impact development with regard to this project?
I'm going to object. This is cross-examination, not voir dire, I believe.
I'm just asking about his qualifications, whether he knows these things.
I'm sorry, that's not what you asked.
I assume your intention is to offer him as an expert witness.
Yes, it is.
I think the questions are appropriate then.
Can you repeat the last question, please?
Sure. Did you, in the development of this project, were low-impact development principles used?
To the extent that we could, yes.
That's all the question I have here.
And you accept him as an expert witness?
I would accept him as an expert witness in landscape architecture, but nothing else.
All right, thank you.
Well, I'm going to ask that he be admitted as a landscape architect with an expertise in land development and all the things that he talked about, just as he is permitted to do under the Licensing Act.
And I have brought a copy of the Licensing Act with me if we want to go through any of the details there.
If I may, have you testified as an engineering expert before other panels, boards and panels?
Yes, I have.
Can you name them?
Amity Township,
Okay,
and it was for another stream relocation similar to this and a large warehouse development. Coomber Township in regards to specifically traffic engineering as well. Dozens of other zoning hearing boards throughout Southeast PA and even into New Jersey as well. Even though I'm not licensed in New Jersey, they have accepted me as an expert. With respect to land development, stormwater management, and there was a stream relocation project I did in New Jersey as well.
with respect to the issue we are here for tonight,
Correct.
relocating the unnamed tributary,
Correct.
am I understanding you?
No, go ahead. I wanted him
Oh,
to let
okay.
you finish. I'm sorry.
Am I understanding you to say that you've been accepted as an expert on one other occasion with respect to that issue?
Yes.
So this would be your second.
Second in PA, third if you count New Jersey as well.
Would have a feeling?
No,
What's that?
I don't have any objections to this right now. No.
No objections to accepting him as an expert witness? Okay. The board will recognize him as an expert witness.
Thank you.
Mr. Haas, are you familiar with the property that is the subject matter of the hearing this evening?
Yes, I am.
Can you confirm for the record where the property is located?
It is located on the north side of Wood and Hackett Avenue to the west side of the Bushkill Creek. And Bushkill Creek also wraps around to the north side of the project as well.
And I direct your attention to behind you. I believe that's Exhibit A6, is it not, Jess?
Yes.
Yeah. is this the property that you were describing?
Yes, it is.
And is there anything else that you would like to say about the property?
Specifically, what we're looking at here is the existing conditions for the property, and it shows the floodplains for the Bushkill Creek on the right side and for the unnamed tributary. The blue is what FEMA has mapped for the floodplain. FEMA's mapping, when they go through it, is based a lot on aerial imagery and some other factors. Their floodplain mapping was a little bit more extensive than what would be appropriate for the site. The purple that you see there is from our modeling of the floodplain using the same data that FEMA uses for flows and with a more updated and accurate survey that we had. So we took FEMA's floodplain and essentially said it is smaller than what they're showing. It is the purple that we are showing on there.
Don, if you would turn around to the drawing, is this part of A6, basically the lower right-hand corner of the drawing, the area of the property to which our application is limited tonight?
Correct. It is specifically this heavy dashed line that I'm going to point to is the limits between Wilson and Easton. The application is just on the east side of that line.
Okay. Now, Jess, if you would give us A3. Can you confirm the zoning of this property for us, I guess with reference to this zoning map?
Correct. It is shown there and labeled in the adaptive reuse zone.
And am I correct that portions of the property are located within the flood hazard overlay district?
Correct. Portions are.
And that's the area that you just referred to on the previous exhibit A6, is that right?
Correct.
Leave that up, we'll get to that next one, Jess. Now, we're gonna put up A4. Could you identify A4?
A4 is a FEMA mapping showing the floodplains on the property.
Now, what are the qualifying criteria for the flood hazard overlay zone? Meaning, what properties, what in the ordinance requires a portion of a property to be treated in accordance with the floodplain management ordinance?
Any portion of a property that is shown on a FEMA floodplain map within the 1% chance flood or the 100-year flood, which is what's shown here in blue, and any identified flood hazard areas per the FEMA flood insurance mapping.
Now, using this, is the drawing that's up there, is that the FEMA, is that the drawing that accompanies the FEMA flood insurance rate materials?
Yes, it is.
So, using that map, can you please describe for the board the portions of the property that are located in the overlay district?
That would be the portions shown with the light blue and the portions shown with the red hatching for the Bushkill Creek.
Now, Jess, if you would bring us back A7. Now, referring to this plan, I think this is called the proposed plan of relocation. Is that correct?
Correct.
and that's A7. Please explain to the board what is proposed in the flood hazard zone.
So the flood hazard zone, as was shown on the FEMA mapping on the existing conditions, what we're essentially doing is we're relocating it because we're relocating the tributary that goes to the Bushkill Creek. So the flood hazard mapping would flow, in existing conditions, it would be further north than the red area shown on here. It would be where our driveway is and where the detention basin is shown there. So in relocating it, the new 100-year floodplain will be in the red area as shown on this plan.
And are these uses and activities that you just described, are they permitted in the flood hazard overlay district?
Yes, they are.
Now, if you could, what sections of the floodplain ordinance permits the proposed relocation and the associated uses and activities proposed, that we propose to conduct in the flood hazard zone?
Those are sections 298-13A, 2, 3, and 6.
Could you tell us what they cover?
They cover flood control structures, including dams, culverts, bridges, altered or relocated water courses, and utilities within the floodplain.
Can you confirm for us when our special exception application was filed?
July 8th, 2025.
Can I interrupt? I just want to make sure I heard correctly. Did you indicate that what you're proposing is permitted under 298.13A 2, 3, and 6?
I believe that's
Yes.
what he
Is that
said.
your testimony?
Would you like us to go through each of those sections?
Well, it's just that I am looking at 6, and it says certification from a registered professional engineer, architect, or landscape architect that the proposed construction has been adequately designed to protect against damage from the base flood. I don't understand how that authorizes what you're proposing.
Let's make sure that we're giving you the right
That's
number.
why I,
Yes.
Yeah,
298.13A, which one?
6.
I'm reading it as a storage and disposal of soil, loam, peat, sand, and other materials.
Right.
I have a copy, fresh copy. We have the same thing.
Apparently, my paralegal skipped a page when she was copying this for me, and that's the reason for my confusion. I do apologize.
You scared the hell out of me that we blew it.
Thank you.
So, just so we're clear,
Okay.
those 3 sections permit by special exception, and you referred to 3 different sections.
Correct.
So tell us what does 2 say, because it's a long list of things.
2 allows us to install the culvert. The relocation of the waterway, which is the biggest portion of this project, is relocating that.
And that's specifically set forth in the second sentence or the second line of subsection 2, is it not?
Correct.
Okay. What is 3? Is 3 even relevant to us?
3 is for utilities. It's kind of a technical item where We are placing utilities where the existing floodplain is within the city of Easton underneath that roadway, but once we relocate the stream, then it's kind of a moot point, but technically, yes.
And the last one, 6.
6 is referring to the placement of soil materials within the floodplain. And we are doing filling activities in order to construct the relocated tributary and the other elements of the project.
And you told us that we submitted the special exception application on July 8th, 2025. And is a copy of the filed application the document that has been marked as Exhibit A9?
Yes,
Okay, and that's the document that we submitted.
correct.
Okay. Now, before we get into the merits of the special exception, I would like to review for a moment the filing requirements, because there were some questions raised at the August 6, 2025 Planning Commission, whether our application was complete. What sections of the floodplain management ordinance contains the filing requirements for special exception applications in the floodplain overlay district?
That is 298-14A.
Now, we have as Exhibit A13, that section, 298-14 special exception application requirements, correct?
Correct.
And did the special exception application, which we filed on July 8th, comply with the requirements of this section?
Yes, it did. There was some contention with the Planning Commission that not all elements were there, such as the proposed building plans. This application is not related to a building, so there was no building plans for us to provide. There was some issues with just elements. This list covers every possible special exception you could have in your floodplain, and ours is specifically limited to the items that we've been discussing.
So, turning to A13, the filing requirements of 298-14A, there's a long list there, isn't there?
Correct.
I guess my question to you to save time is, do you comply with every one of these requirements except those, such as you're talking about, that were not relevant to what we were doing?
Correct. We complied with all of it except for what's not applicable to our specific application.
Was there anything other than the building requirement that we didn't submit, if you remember?
I believe there were some questions for uplift calculations, but there's no structures that we're providing. Detailed floodproofing measures, but again, there's no structure, so we don't have to provide that. More or less the profiles of proposed streets, but we do not have any proposed streets that are going to be applicable to this. We have a driveway, and we do have profiles of it, but it just kind of gets into a little bit of, it doesn't fit our specific application.
And it's a little bit out of order of what I wanted to do, but this application was reviewed by township staff, specifically the special exception application, wasn't it?
Correct.
And it was found to be complete, wasn't it?
Correct. They provided no comments or any indication that there was elements missing.
Now, I'd like to direct your attention to 298-15 of the Floodplain Management Ordinance, entitled Application Review Procedures, a copy of which we've also marked as Exhibit A14, and ask you to read the highlighted portion into the, do I have the?
We took that out.
You took that one out. Okay. Let's go on. Now, do you have knowledge as to who serves as the floodplain administrator for the city of Easton?
I believe it used to be Steve DeSalva, who has retired. I think it now is Carl Manch, but I'm not 100% sure.
And did we receive correspondence from Mr. Manges in connection with the special exception application?
Prior to our application, just as notification that we were required to provide that and some clarification on questions for the application. But after that, there was no correspondence.
And is that same document Exhibit A? Can we turn to Exhibit A11?
So this was provided at the Planning Commission meeting, and it's the staff review from the Planning Department of the city for the project,
And
and
who is it from?
from Carl Mange,
And what's the date?
July 29th, 2025.
And this is the document that I read the last page of in my introduction, did I not?
Correct, for their recommendation.
Is this the staff's recommendation or approval of our floodplain application?
I took it as such.
Now, just to wrap this part of it up, is it your testimony that our client or you submitted all applicable and relevant documents with respect to the special exception application as required by specifically section 298-14A of the floodplain management ordinance?
Correct.
Okay, let's shift a little bit. I'd like to get to the objective criteria of the ordinance. Mr. Haas, is it your understanding that the special exception application is required to demonstrate compliance with the specific objective criteria contained within the floodplain management ordinance applicable to the proposed floodplain activities and uses?
Yes.
And what section or sections of the floodplain ordinance identify the objective criteria applicable to the proposed floodplain uses and activities?
Article 5, Section 298.10, specifically for permit requirements and general technical provisions for construction and development within the flood hazard areas. Article 6, Sections 298.13B and C, for identifying requirements applicable for special exception applications. Article 8 of the floodplain management ordinance contains the technical provisions for permitted special exception and variance approvals.
Okay, let's walk through each of those requirements, beginning with the general technical requirement provisions of 298.10. Would you tell us what that says?
That says that no encroachments, alteration, or improvement of any kind shall be made to any watercourse until all adjacent municipalities which may be affected by such action have been notified by the City of Easton, and until all required permits or approvals have first been obtained from the Pennsylvania Department of Environmental Protection. In addition, FEMA and the Pennsylvania Department of Community and Economic Development shall be notified prior to alteration or relocation of any watercourse.
What what are the adjacent municipalities that require notice?
Borough of Wilson.
Now, Palmer does not. Why is that?
They're not affected specifically by this floodplain. It's within Borough of Wilson and City of Easton.
But Palmer was notified.
They got a courtesy copy of all our plans for this application, for all of our land development.
Have all permits and approvals been obtained from the Pennsylvania Department of Environmental Protection?
Yes, they have.
And they are what?
The Pennsylvania NPDES permit and the Chapter 105 Waterways and Encroachment permit.
And can you confirm that the permits that I went through in my opening at A8D and A8E are those permits?
E and F are the permits.
Okay, thank you. And will our client or you notify FEMA and the Pennsylvania Department of Community and Economic Development prior to any alteration or relocation of the water course?
Yes.
Okay. And will all construction, development, uses, and activities be undertaken in strict conformance with the provisions of the floodplain management ordinance and any other applicable codes, ordinances, and regulations?
Yes.
Will the proposed floodplain encroachments, new construction, use, activity, and/or land development, will any of them adversely affect the capacity of the channel or floodway of any water course, drainage ditch, or other drainage facility or system?
No, it will not. As we have designed it, we've expanded the stream. Part of relocating it is daylighting it. I didn't get into this earlier, but the existing stream, if you can see right in the middle there where the blue expands, there's a black hatching. The existing stream is underground for a significant portion there. It's long enough that fish from the Bushkill Creek don't swim up it. It's just too dark. They're not going to go up it. So once we relocate it, essentially daylights it. So now we're providing habitat connectivity and letting the fish go back up the stream. With our proposed design, we also, you can see here within the red is some blue areas. Those are wetland benching. It just allows for a little bit of extra floodplain benching. So during flood events, the water can flow out. So we reduce some of the velocity of the water as it comes down that stream. It was not a specific requirement of our design, but we added it to add additional habitat along the stream. Since we're getting fish up it, we want it to be healthy, natural, and to mitigate any sort of flood concerns.
Now, there's some sort of requirement for getting data for the base elevation, the base flow elevation. Were you able to get that data with the creek being in a pipe?
It's based on the drainage areas that go to the creek. So it's everything upstream of our property that would drain to that creek and provide flow within that creek there, as well as the drainage on our property. So we had hard survey of that, and we can model our specific drainage and contribution to the creek.
So you were able to get
Yes.
the necessary information. Thank you. Now, and was the application supported by hydrologic and hydraulic engineering analyses that determined the base flood elevation and floodway information of the unnamed tributary?
Yes, it was.
Now explain all those words I just said.
So what we do is we model the existing as everything kind of flows through that stream.
What does model mean?
We take the data of what the flow is, the surface conditions, the slope of the stream, everything that's contributing to what would contribute to flow going into the stream. And we use a program called HECRAS to show what that flood elevation and how the stream acts during the extreme flood events, in this case.
So it's a
100-year.
It's a computer program that you input all of the necessary information
Correct.
for that, and the HECRAS program was originally created by the Army Corps of Engineers.
Correct. Specifically to model flood elevations and floodplains.
And it is the accepted tool for doing what you're talking about, is it not?
Correct.
Okay, so I took you off course. So come back to what you did, what the modeling meant, and what its result was.
So our existing modeling showed the purple that's shown on here, and showed that FEMA's assumptions were a little bit greater there. FEMA didn't take into account, for instance, where it's underground. That's why FEMA's mapping shows it as expanding. They just had an elevation on the surface there. They didn't realize there was a pipe there that would affect the flood elevations. So our purple that's shown on there is the existing conditions that we came up with during our modeling to show the base flood and how that affects the stream and what we needed to account for in our proposed modeling then as well. So then in our proposed modeling, we took the data for everything flowing essentially just to the west on the other side of the road. I'm not sure if you can see the mouse. Everything flowing to there in the existing conditions was the same. We didn't change any of that flow. And then we added in our development and how that would affect the flow and the water going to the stream in this instance.
And a copy of your hydrologic and hydraulic report is Exhibit A15, is it not?
I believe A14.
I may have messed up some of these numbers. Okay.
Yep, A14.
A14, thank you. And the analysis that you did was reviewed by a licensed professional engineer, Greg Bozier, was it not?
Correct.
And in fact, he stamped the report, did he not?
Correct. As we do this for the city of Easton and in Pennsylvania, I can stamp it, but FEMA does not recognize landscape architects, unfortunately. That's separate between the PA board and federal requirements.
Now, jumping ahead for just a moment, Section 298.13C requires that all hydrologic and hydraulic analysis shall be undertaken only by professional engineers or others of demonstrated qualification, who shall certify that the technical methods used correctly reflect current accepted technical concepts, studies, analysis, computations, etc., shall be submitted in sufficient detail to allow a thorough technical review by the City of Easton, the Department of Planning Codes, and the city engineer or authorized third-party engineer. Did I read that correctly?
Yes, you did.
Was the hydrologic and hydraulic study prepared by you and Mr. Bozier?
Yes, and also with assistance from Dr. Ben Bahani from our offices. His doctorate is specifically in environmental engineering. So we worked collectively together on the report, and the final sign-off was by Mr. Bozier.
Thank you. It might be redundant, but was the hydrology and hydraulic study prepared in accordance with commonly accepted technical methods for preparing such analyses?
Yes, it was. We just used the standard HECRAS requirements and the Army Corps requirements because they're also a reviewing agency for this.
I'd like to take you to section 298.10. And again, I'm going to read it, quote, "Within any floodplain area, no encroachments, including fill, new construction, substantial improvements, or other development shall be permitted unless it has been demonstrated through hydrologic and hydraulic analysis performed in accordance with standard engineering practices that the proposed encroachment would not result in any increase in flood elevation within the community during the occurrence of the base flood discharge." Again,
Mr. Solicitor, he has testified he's not an engineer and that he is not a licensed engineer and doesn't have any kind of engineering degree. He's now being asked whether the methodology used for the engineering here is proper and accepted methods and standards. And he does not have the expertise to be able to testify to that. So I would object to him testifying to this.
a licensed landscape architect in Pennsylvania is authorized to perform this kind of work. He's testified that he has done it before many times, and he's testified that he did it in conjunction with Greg Boja, who is a licensed engineer and who sealed it, and with another gentleman who's got total credentials. And, you know, the
Counsel, let me interrupt you. Does what you're testifying to now relate to the requirements, counsel, if you can look with me, under 298.14 subsections 6, 7, 8, or 9?
Wait a minute, let me see where I was. I had just read to him section 298.10F, but I have a copy of the ordinance here if you want me to come to the other page.
If you wouldn't mind, because there's a reason I'm asking.
Go ahead, give me that again, 219.
298.14.
298.14 sub 6, 7, 8, 9. These are the certifications and statements that are supposed to accompany the underlying appeal.
Okay, so 6 is
Certification from,
professional registered engineer, architect, or landscape architect, that the proposed construction has been adequately designed to protect against damage from the base flood. His certification is in our materials, and I'll get to it.
right, what I'm asking is, does what he is testifying to and what is being objected to cover, is it covered under 6, 7, 8, or 9?
Don, would you
I believe it is.
In what respect?
This,
First of all, quite honestly, I was writing, so I missed what you said that was objected to. So if you could repeat what you said and then tie it in with one of those numbers.
I did not get to ask the question. What I was talking about, I had read section 298.10F, within the floodplain, no encroachments, etc., unless it is demonstrated through hydrologic and hydraulic analysis performed in accordance with standard engineering, that the proposed encroachments would not result in any increase in the flood elevation within the community. And then I was stopped
Okay.
before we could get to these certifications.
I believe that would be under certification number 6, has been adequately designed to protect against damage from the base flood.
I believe there's a difference between protecting against damage from the base flood and increasing the base flood.
Well,
Arguably, one would probably lead to the other
Well,
anyway.
10F says that you cannot do anything that would result in any increase in the flood levels within the community.
Statement certification number 8 discusses the complete and accurate description of the effects the proposed development will have on base
Oh, wait a
flood
minute.
elevation.
Now, I believe it fits under 8.
Yes, yeah.
So respectfully, the objection is overruled because those sections specifically state that the statement certified by a registered professional engineer, architect, landscape architect, or other qualified person. So
Thank
the objection is overruled. Sure. And you are?
My name is Brett Weber. I'm an architect in Easton.
Objection. This man's not counsel.
I'm an individual objector.
I
I have signed in and
I understand
I'm a
that.
resident.
We're not going to accept an objection from you. When he's done testifying, you can cross-examine him. Okay?
Thank you. Don, I think you've answered this question, but I read 298.10F, and it basically said activities would not result in any increase in flood levels within the community during the occurrence of a base flood discharge.
Correct.
Okay. Do the results of the H&H study demonstrate that the proposed relocation and associated encroachments will not result in any increase in flood levels within the community during the occurrence of a base flood discharge?
Correct. The study shows that there's no increase in the base flood in the community.
Now, the next section,
Can I interrupt, counsel? In your own brief, and correct me if I'm wrong, because I don't profess to retain all 22 pages of it as I sit here,
neither do I, but go ahead.
but wasn't there a statement in there that in some areas of the tributary, the relocated tributary, the base flood would be increased by up to under 1 foot?
Per FEMA regulations, you're allowed to, but we are not increasing the base flood elevation.
So you're saying that the indication in his brief is incorrect?
If that's what,
I guess I'm just trying to keep the record clear.
no,
Correct.
I know that Don's right because I have gone to both sets of regulations recently. And FEMA or DEP, the prohibition is not increase the flood level by more than 1 foot. Many municipalities don't allow you to do that. And what he has testified to a number of times is, while we might have been allowed to under FEMA, we did not increase the base level.
Okay, well, and that makes sense because as I recall, I think your brief says it increases it by under 1 foot in some places, but decreases it by more than that in others, so that overall there's a net decrease. I believe that's what your brief says.
It's hard to make that kind of comparison.
Okay.
As we look at it is where it leaves the property.
Okay,
There is no increase in the base flood elevation.
all right, thank you, and that's your statement.
Correct.
Number 50, I'm sorry, 29813B provides no application for a special exception permit shall be approved unless it can be determined that the structure or activity will be located, constructed, and maintained in a manner which will, number one, fully protect the health and safety of the general public and occupants of the structure. At a minimum, all new structures shall be designed, located, and constructed so that A, the structure will survive inundation by waters of the base flood with minimal to no lateral movement or damage to either the structure or to any of the equipment or contents below the base flood elevation. Now that's A. Can you address that?
So it gets into a little bit of definition of structure in your ordinance, which I think relates it specifically to buildings. We do not have any buildings involved in this application anywhere near the floodplain. If we want to get into nitty gritty, we do have a culvert as part of this. If you want to consider that a structure, it is designed to meet all the requirements of the ordinance. It will get set. It actually has the bottom foot of it is stream bed material, so it's embedded into the ground. It has head walls and is secured as required by all ordinances.
Now, B really doesn't apply because it says the lowest floor, including basement, so we don't have to deal with that. C, I'm not sure we have to deal with this either. The occupants of the structure shall remain inside for an indefinite period of time and be safely evacuated at any time during a base flood. That's not relevant to this either, is it?
Correct. It's not part of our application.
Okay. Um, 29813B2, no application for special exception permit shall be approved unless it can be determined that the structure or activity will be located, constructed, and maintained in a manner which will prevent any significant possibility of pollution, increased flood levels or flows, or debris endangering life or property. Can you tell us how you meet that requirement?
The stream is designed to flow freely. Like I said earlier, we have the wetland pockets to provide some floodplain benching, but there's nothing to be placed within that stream that would impede flow or cause debris or pollution downstream. For the utilities that we have crossing it, it's going to cross above the culvert, so the utilities will not be within the flow of the stream or possible to undercut them. The only essentially structure in the stream is the culvert itself, and that is designed to handle the flows without backing up and causing any issues.
Do the results of the H&H study confirm that the proposed uses will be located and constructed in a manner that will prevent the possibility of pollution, increased flood levels, or debris?
Yes.
Let's turn to the technical provisions contained in Article 8 of the Floodplain Management Ordinance, beginning with Section 298.20, which governs the alteration or relocation of water courses, and further indicates alteration or relocation of water courses includes but is not limited to the installation of culverts and bridges. Are you familiar with that section?
Yes.
Okay. Now, when we get to B, it provides that no encroachment, alteration, relocation, or improvement of any kind shall be made to any water course until FEMA, PADEP, and all adjacent municipalities which may be affected by such action have been notified by the municipality, and until all required permits and approvals have first been maintained. Have you done that?
Yes, we have.
Okay, well, tick it off.
For FEMA, we have with them right now is what they call a conditional letter of map revision. FEMA is not an approving agency as far as permitting this to occur or not occur, but that conditional letter of map revision in front of them is essentially the notification to FEMA, and it allows them to review the H&H study, the drawings, and the details for this, so that once construction is done, we will do an as-built, and if the as-built matches the design plans, they issue a letter of map revision and update their firm maps. Wilson Borough, their floodplain manager is Monica Walls from TNM. She has also reviewed the H&H study because the relocation is also occurring in Wilson Borough, and has signed off essentially on that review of that portion of the project.
NPDES.
DEP has issued us our Chapter 105 Waterways and Encroachment Permit, essentially approving the relocation of the stream. This is one of those rare projects where DEP kind of sat up and said, oh, you're essentially daylighting it, you're moving it away from contaminated soils, which Jeff will get to for testimony later, and improving habitat connectivity. This was a rare one where DEP was almost, I won't say in support, but encouraged that we were trying to do something beneficial for the environment with this stream.
Now, that permit is a joint permit.
Correct.
And the joint party to that is the Army Corps of Engineers.
Correct.
And will you tell us where you are with the review by the Army Corps of Engineers?
We have had everything, essentially when you do the joint permit, you submit it to DEP and they submit it to the Army Corps of Engineer for the joint permit review and approval process. It has been with the Army Corps of Engineer for well over a year now. We're at the final stages where they are requiring an escrow be put up.
Let me stop you. But you're at the final stages, meaning what? Have they reviewed everything?
Yes.
Have they signed off on everything?
They provided us comments, requested additional information. We gave it back to them, and the last thing they have asked us for is an escrow agreement.
And they want an escrow agreement for what?
For once the stream is relocated, to ensure that there is money set aside for any future maintenance, if something needs to get fixed, if there was a problem with the construction or some other unforeseen occurrence, there is money set aside separate from any developer that can be used then to make any repairs necessary.
And since your client or our client does not own the property right now, they don't want to put up escrow until they get the approvals and start construction.
Correct.
Is that correct?
Correct. That's
And
one of the final stages before construction.
And so that fund, that escrow fund, will be posted before the construction starts.
Correct.
Has Pennsylvania Department of Economic Development been notified of the proposed relocation?
Yes.
Wilson Borough and Palmer have.
I'm sorry?
My name is Cody Harding. I represent two individual objectors. I can provide evidence of that or just clarify my objection, whatever you want me to. I just want to object that he said Attorney Kaplan just said Palmer was notified, and yet earlier this evening he just said that Palmer didn't, or his witness just said Palmer didn't need to be notified because the floodplain wasn't in there. So I just would like clarification of which one it is.
We provided Palmer with all copies of our land development project
Yeah, I think
because
that's
the property
I just want to
is part of
clarify.
it. So,
Yeah,
because they made a
they were
point to say-
provided with copies.
He said,
I don't think there was a formal notification, but they were provided with copies. That's my recollection
Okay,
of
but
his testimony.
to be clear, he did testify earlier that Palmer did not need to be notified about the relocation of the water course because the flood zone was not in Palmer.
And the record will reflect what the record reflects.
Okay, thank you. Oh, anything else, counsel?
Conflicting testimony by the expert.
I can't hear him.
He indicated his observation that there was conflicting testimony from the expert witness.
So, is it accurate, Don, that you have received from all the outside agencies approvals of your plan?
correct. The
And
last thing is the Army Corps escrow.
Okay. Now, there's another section, 29820C, I'll read it quickly. No encroachment, alteration, or improvement of any kind shall be made to any water course unless it can be shown that the activity will not reduce or impede the flood carrying capacity of the water course in any way. Can you address that?
As our stream is designed, it will not decrease the flood carrying capacity. We actually, like I explained earlier, provided those wetland pockets and floodplain benching to improve the flows there.
Now, could we go on to section 29820? And this is a series of requirements with regard to FEMA. Can you summarize these requirements and tell us how you have complied with these requirements?
So the requirements are to file a letter of map revision showing the changes for the stream, show them the hydrology and hydraulic report to show that we do not increase the floodplain or the base flood elevation, that we have made everything designed to be safe and consistent through our design. Like I said earlier, they're not an approving agency. FEMA kind of designated all municipalities to have their own floodplain ordinance to do that for them, but they will update their flood mapping once we get the letter of map revision and the as-built survey of the project.
Is there anything else left to be done with FEMA before the work is done?
No.
Does the proposed relocation propose any development in the A1-30 or AE zones of the flood map?
So the AE zone of the flood map is specifically within the Bushkill Creek. We're not doing any work within the Bushkill Creek that would affect that. We are what would be Zone A, which is not part of that.
Now, there are some of these sections, the 298 sections, that refer to what happens if you're creating or involved in a residential structure, correct?
Correct.
Is it correct that we are not involved in any residential structure?
Correct.
And therefore, whatever those provisions are not applicable?
Correct.
Similarly, there's a definition of accessory use or structure in the ordinance. And are you familiar with it?
Yes.
And do we have any accessory use or structure that is being introduced into the floodway,
No, we do not.
or floodplain, excuse me? Now, section 298.26 governs the use of fill in the flood hazard district and provides if fill is used, then there's a number of requirements. And are you familiar with them?
Yes.
Can you describe them or take us through and tell us either how they're applicable, not applicable, or that we're complying with them?
So the material is one of the requirements. It has to be small rock soil material. We're not constructing the flood banks and the stream with like large chunks of leftover concrete. We're doing it with the appropriate materials. No slopes greater than 2 to 1. So our side slopes at our stream are 2 to 1 or flatter than that to be compliant with it. The material has to be compacted. That's kind of, we'll get into the technical specs during construction to make sure that it's constructed correctly and that the stream doesn't erode into the future. We want this to succeed and be a good stream. And not to affect any adjacent properties, which is a vital part of our design, is to make sure it is safe.
And is it your opinion, or can you testify for a fact that what's proposed will not violate or will comply with all those requirements that you just talked about?
The design will comply with all those requirements.
Okay, let's move to section 298, 27. Now that covers drainage facilities and states that storm drainage facilities shall be designed to convey the flow of stormwater in a safe and efficient manner. The system will ensure proper drainage along streets and provide positive drainage away from buildings. The system shall also be designed to prevent the discharge of excess runoff onto adjacent properties. Can you comment on those requirements and whether or not your design complies with them?
Our design does comply with them. With regards to the street, Hackett, is it Hackett or Wood? Wood Avenue, where our driveway entrance is, we're installing stormwater inlets there to capture any of the runoff on the street and from our driveway. The stormwater inlets are part of the application there because they run over top of the stream to the north into our detention basin there, so that we manage even the driveway as it crosses over the creek. All the stormwater from the site goes through a series of basins to filter it. Our basins have what are called a managed release concept. They have 2 to 4 feet of soil material, so the water goes into it, filters through the soil material, and then goes out an under drain. Specifically for the first flush that comes off any of the paved areas, we always consider that the dirtiest. This is a DEP design that we're using for it, and their goals are the same: is get the water, clean it, filter it. When there is a 100-year storm, the first flush will get down into that, and then the larger storms will flow through a regular outlet structure for a basin. But the 2-year storm and below, those are meant to get filtered every single time, provide clean water, and keep any pollutants from going into the stream.
Let's move to the stormwater management facilities for the proposed development, as opposed to the very limited little piece that we're talking about here. Did you design the stormwater management facilities
Yes.
for the proposed development? And I'd like you to go to, well, let's go first to Exhibit A8B. And I would like you to identify it.
A8C
Yeah.
would be the Pannoni Associates.
Yes,
Pannoni
exactly.
is City of Easton's reviewer.
Right.
They have
So tell us what this is.
they have reviewed our stormwater design, and their letter says it is consistent with the stormwater ordinances for the City of Easton. It's one of those standard processes as we submit our documents to the city for review. They've done that review for the city as a separate entity.
So they are the town, the city's consultant.
Correct.
Stormwater.
Correct.
And let's go to the next document. D is the LVPC letter. Can you tell us what this is?
LVPC essentially has jurisdiction because of the Bushkill Creek Act 167. They do the same review that Pannoni does, make sure our stormwater design is consistent with the Act 167 ordinance. And their letter here has shown that we are compliant with it, and they agree to our design.
And the next one is an email, and tell us what the,
I think you want H. H is the
yeah.
email correspondence with the Conservation District. This was a question brought up at the Planning Commission. The Conservation District doesn't issue a permit directly. Their permit is combined with the NPDS permit that is issued from DEP. So essentially the email is from the Conservation District saying that our erosion and sediment control during construction to make sure no silt and sediment goes into any of the streams is correct and compliant with the state requirements for that.
Section 298-28 governs water and sanitary sewer facilities and systems, and provides that, quote, all new or replacement water supply and sanitary sewer facilities and systems shall be located, designed, and constructed to minimize or eliminate flood damage and the infiltration of floodwaters. Does the proposed development comply with that standard?
Yes, it does. We have a water line that's in the proposed driveway. Again, it crosses above the culvert. That's a standard water line. It'll have a sufficient cover because the culvert crossing is tall, so that it will not freeze 4 feet above the culvert and 4 feet below the surface of the roadway there. That is the only water facility that would be within a floodplain and kind of floating above it, more or less. As far as sanitary facilities go, we propose a connection to an existing sanitary line that runs along the Bushkill Creek. I'm going to try to draw it on here. From the building down to that, if you can see the blue line that I added, that is actually outside the floodplain for the Bushkill Creek. We picked one of the locations where the existing sewer line is outside the floodplain. So we do not have any sanitary facilities as part of our project proposed within any floodplain. So that section is more or less not applicable as far as sanitary.
Will the design and construction provision of the City of Easton's building code and the FEMA provisions for the protecting building utilities from flood damage and the International Private Sewage Facility Code be utilized for the construction of the proposed development?
To all extents where they're applicable, yes, they will.
So we're not going to have a private sewage disposal here, so that code will not be applicable.
That's not applicable, and anything related specifically to the building itself is not applicable.
I think you've answered this, but have the utilities for proposed development, gas lines, electrical and phone lines been located, elevated, and designed to minimize the chance of impairment during floods as required by 29829?
They have. Essentially, all the utilities are above the flood elevation, so they will not be impacted during a flood event.
Will any new streets be constructed?
No, just the proposed driveway.
Will a finished elevation of, this is almost redundant, of new streets be more than 1 foot below the regulatory flood elevation?
It's not applicable because we don't have streets, but the driveway itself is above the flood elevation. So even during a 100-year flood event, the driveway is not impeded in any way.
And section 29831 gets into buoyancy, flammability, explosive materials. Is any of that relevant to this application?
No, it is not.
Because we're not building any building within the floodplain.
Correct.
Again, let's cover it. 29832 governs the placement of buildings and structures in the floodplain hazard overlay zone. What's your comment to that?
It's not applicable.
We're not putting any buildings
Correct.
in the floodplain. Next one, 32B, talks about anchoring buildings in the floodplain. That too is not applicable.
Not applicable.
32C refers to large pipes and other similar objects or components located below the regulatory flood elevation, and are they properly secured?
The only thing that would qualify for that would be the culvert itself. They're standard. We're kind of pulling a off-the-shelf culvert design, nothing new. We don't have to go get something re-engineered or designed from scratch that is meant to carry these types of waters.
And finally, does the floodplain management ordinance contain any other requirements applicable to the proposed relocation and associated encroachments?
Nope, I think we have covered everything thoroughly tonight.
I have no further questions. I would really like a couple of minutes break.
I'm sure you're not alone.
I think I speak for a lot of people in the room.
Mr. Chairman?
Yep. 5 minutes.
I will caution everyone. Do not approach or speak with any of the board members or myself while we are on our way to or from the facilities down the hall. Okay? Thank you.
Hold on, Mike. Let me turn it on, buddy. Yeah, it's on now.
All right. If I have order, please. We're going to start again. I think we left it off with maybe, I don't know if the board has any questions for Mr. Haas right now. Any questions from the board?
Do you?
I'll ask one question. You stated earlier about the, in one of the 298ers there, it mentioned about any new construction. So are you telling us with that study that you did with the new construction of the warehouse, that the water from that's not going to impact what you're doing?
So that gets into the stormwater approvals that we already have. Essentially, the Bushkill Act 167, City of Easton's ordinances, and Wilson Borough, also their ordinances have, and DEP, we are not allowed to increase the drainage from our site. And that's what the detention basins are. So the rate that we're discharging water from our site has to be same as existing conditions or less than. So the basins take the water up and meter it out. So they're not going to be it's not going to just run off the building and the truck courts and dump into the water and raise the elevation. They are captured, various stormwater facilities across the site. We have the 3 big basins. On Wilson's side, we have a smaller basin and rain gardens along the street because we had a little bit of the street portion that we couldn't get into a basin on Hackett that we had to manage. So we put that linear, you can see this thing here is a linear rain garden to capture it. So we're even looking at any of the street improvements because PennDOT's is requiring a little bit of widening, a turn lane in. We even have to manage and capture those portions of it.
Just out of curiosity, when you do your model based on those basins, are you using a typical rainstorms or these the 100-year floods? Because
we have,
just to say, we all see what happens to our storm, sewers.
mm-hmm.
When you have a massive downpour, inches an hour, they tend to back up. Can your basin handle that first, cleaning sediment basin? And if it does overflow, it only has one place to go, which is potentially the unknown tributary, which does go into the Bushkill Creek.
So the basins are designed for up to the 100-year storm, which is the ordinance requirement. We do look at even the smaller storms, the 1 year, 2 year. I don't think we do the 5, 10, 25, 50, and 100. And then the ordinance requirements are to look at those, and existing has to match proposed, or proposed has to match existing on each of those instances. Because you could get, as you design these and you model the basins, if you don't do it correctly, you're manage the 2-year storm, everything's good, but then the 50-year storm. So then you go manage that one. So it's designed for all those storm variations to show that we're compliant with the ordinances and with DEP regulations.
All right. Any other questions from the board?
Mr. Chairman, before you open it up to questions by council and anyone else, Mr. Tillman did want to put one thing onto the record.
So on the record, when Donald Haas stated who the floodplain manager was, it's myself, and the engineer that reviews it for the city of Easton is Mark Hammerstone. So it was Steve
Okay.
DeSalvo that reviews it. Now it's Mark Hammerstone.
Okay.
So just to be clear, so that's on the record.
Thank you.
All right, so now we'll take some questions from, I don't know if any attorneys out there that wanted to come up and ask questions to Mr. Haas right now.
Do you want me to introduce myself?
Please, please.
Again, my name is Cody Harding. I'm an attorney representing 2 objectors. One is a community organization, the other's a nearby resident. Can I ask a question? You need more than that?
I think Mr. Harding ought to identify his client and where his client lives, so that we know what proximity they are to.
I'm happy to do that. I am a little worried we're going to get sidetracked in a long discussion about standing again, but my clients are, one is Mr. Tim Haas, who lives immediately adjacent to the property on the north side. His residence can be seen on the plans. And then I also represent Stone Root Inc., doing business as a Stopwood Warehouse Coalition, which includes 516 members of the community, including Tim Haas and other adjacent businesses and concerned residents.
All right, thank you.
You're welcome. Can we see this map that we've just been discussing? I think it's applicant's exhibit A7. Are there topographical lines on that map?
This map does not have any.
Okay. Now, we've talked about how 10% of the building is in Easton. I think that was said by council and maybe also by Mr. Haas. Could you estimate what percentage of the retention basins and other related construction are in Easton?
I'm going to object because this does not have to do with the floodplain relocation.
The retention basins and the related construction do have to do with the storm or the
I thought the basins
Floodplain.
were part of what you were proposing.
Yeah.
I'll withdraw it.
Right, thank you.
Easier to have him answer it.
Okay. Proceed.
I'm just kind of eyeballing it. Estimate 60 to 70%.
Okay, so it's safe to say a majority of the stormwater retention basins and the stream relocation work is located in Easton.
The basins are, the stream relocation is probably about 50-50.
And have you appeared before Wilson's zoning board for any variances or other approvals?
Not the zoning board. We have Wilson Borough Council approval.
Did you do any 3D modeling or any other like three-dimensional imaging of the site after construction?
Me, myself, no.
Or your firm?
We have our design drawings, which include 3D elements, but nothing that is like a published element. It's how we work through our design and make sure that everything is functional. Stormwater has to flow downhill. We need to provide grading to accomplish that.
But none of those 3D modeling or visualization were submitted as part of your special exception application or other submissions to Easton?
No.
And do you have a copy of any Army Corps approval?
The Army Corps approval has not been issued because we need to provide the final escrow. We have been regularly in contact with the Army Corps in case they have any additional questions. One of my recent contacts with Justin, I've worked with him for this project and several other projects. He did note a call from you, Mr. Harding, regarding questions, and it's actually triggering them to reevaluate how they do their approvals in instances like this where we need an approval, but prior to posting a escrow, in this case, we're looking at something between $100,000 and $200,000. You don't post that until you have all your other approvals.
So you do not have Army Corps approval?
Not
at
the
this
final
point?
approval.
I'd like to look at other maps and exhibits that were submitted and ask Mr. Haas about them, but I have them on my computer. I don't know how to show them to the board.
Do they have them?
Is it
Does he have them?
If you have the number, we have all the exhibits.
Wait. I want to hear what this is about. It sounds like it's beyond the scope of direct examination.
Yeah, I'll present them when I present my case in chief. I have no further questions at this time.
Anybody else?
Good evening. My name is Jeff Fleischaker from Gross McGinley. I'm here on behalf of resident Charles Pax, who lives on Wolf Drive in Easton. Just had a couple of quick questions, Mr. House, I wanted to follow up.
And I'm sorry, what firm are you with?
Gross McGinley.
Gross McGinn.
Sorry.
Thank you.
Mr. Haas, on A7 that we're looking at, is this the map that was submitted to FEMA as part of the floodplain modification request?
FEMA gets more technical maps with
Okay.
it, which shows the grading that's on it. So this is just an overall proposed plan, just to kind of give a general site.
Okay, so following up on Mr. Harding's question, this is a simplified map with no topographical rating regarding where the proposed relocation of the tributary is.
Correct.
Sort of a simplified version for zoning.
For zoning and just for presentation.
Sorry, sort of a simplified version for zoning. I apologize. Please tell me to slow down as many times as you need to.
Correct.
Okay. Have there been other other proposed redesigns or restructuring of this tributary during the development process?
You mean alternate designs?
Potato, sure, an alternate design.
We've iterated through the design more for the sinuosity of the stream. We wanted sinuosity, so as it kind of moves back and forth like a snake going, you see the curves in the stream. Initial design, just to see on functionality, we just did a straight line. That was not a desirable design because we wanted it to be a naturalized stream. We wanted to improve the existing conditions. There's generally stone walls where it is daylighted, or concrete channel lined. So we're trying to, what DEP and the Army Corps calls uplift. And so we provide those naturalized elements, the curves in the stream. We also have wood veins and other little natural habitat elements, not shown on this, but was part of the DEP review because they also coordinate that with Pennsylvania Fish and Boat. So Fish and Boat weighs in on other elements to make the stream natural and adequate habitat.
And the sinuosity that you talked about, and I really like that word, by the way, I'm going to use it more, is it also assists with floodwater management, right?
Correct. It helps when we aim or do our designs so that we have a consistent slope. Essentially, we had 2 points we connected to, is the culvert on Hackett Avenue and Bushkill Creek. Those are hard points. We can't raise or lower those. So we use those points, and then we design the curves there and provided a consistent slope from point A to point B.
Okay. So other proposed or alternate designs of the relocated tributary, they've included moving the culvert north and south in different locations?
A little bit, but essentially we chose a location and worked with that.
Okay. And just to confirm, what we're looking at tonight in A7, what's been presented to the board as evidence of the proposed relocation, this is exactly the final location pursuant to the proposal to FEMA?
Correct. This is a simplified version, but yes, FEMA has a more technical version with all the grades, all the data showing flood elevations, cross sections, and that information.
And you indicated that you've got the conditional floodplain modification approval, right?
We don't have it back from FEMA, but it's conditional letter of map revision.
CLMR, right?
Yep, Clomer. We have it submitted to FEMA. They haven't provided any comments at this point. It's not a hard requirement to do that, but we use that to preemptively get ahead of the curve for when it is constructed, so that all we have to do if the contractor builds everything correctly is submit an as-built and it's done. And it also served as our notification to FEMA of the project.
Okay, so I want to backtrack just a minute and correct me where I'm wrong, but you've not actually heard any positive or negative at this point from FEMA on your CLMR proposal?
Correct.
Okay, so it's not conditioned on the as-built as much as we're hoping that they'll condition it on the as-built.
I wouldn't say that because FEMA also takes into account the municipal reviews and DEP and Army Corps reviews in showing that we've gotten their approvals. They've agreed that this design is adequate.
Okay. And you said, and again, correct me if I'm wrong, you've done this more than I have, that when you present them an as-built, you'll get the formal, the permanent, the POLMR, the PLMR, the permanent land.
They just call it a letter of map revision.
Right.
They just drop the conditional.
Okay. And what happens if it doesn't match?
In that case, if something during construction didn't match our design plans and the as-built showed that, we would have to either come back and redo the modeling to prove that the as-built design is correct and sufficient, or in that case, if it's not, then there might be an instance where the contractor would have to come back and correct anything that they did not do to plan.
Okay.
But that's a construction issue and not a special exception issue.
Okay, and I'm just concerned as we have this conversation about what happens if the as-built doesn't match the proposal for FEMA. Is that something that gets discovered before or after the 1 million square feet of warehouse gets placed in this location?
It would depend on the construction sequencing and how fast they work.
And
The,
I'm gonna take it that
we,
you don't
we
know the
are
answer to
proposing that the stream gets built first. The relocation is early on in the construction process because some of the fill material that, as earth is moved around, will have to go where the existing stream is located. So we would know early on as they build the relocated stream. And what essentially they'll do is they'll start building at the downstream end, close to the Bushkill. They'll not connect it there. They'll leave a berm. They'll build and cut and grade and install everything up until just before the at the culvert there. They'll leave it disconnected. They get everything stabilized. You get your grass and everything growing along the stream banks. And then the last step is to open it upstream and downstream and close off the existing and let the new stream flow. So we will have that ability to survey that early on in the construction process.
Okay, and the as-built that you're providing to FEMA, is that as it flows as-built, as in after you've connected it to the Bushkill and downstream as well, or is it when you are in the middle of the process?
Correct. It is as you flow. As it flows, it is the final condition. That is what FEMA is going to care about.
And if you don't know the answer to this, I understand the limitations of individual experts at this point, but how long between the time that this as-built would be potentially able to be drawn or mapped or
Certainly.
finalized to when shovel to dirt on 1 million square feet of warehouse? Shovel to dirt. Digging on the warehouse on the top of the hill there.
So that'll get into a contractor construction sequencing on how quick they intend to build it. That's kind of a little past the point of right now.
But right now, we don't know if some of the initial construction of the 1 million square feet of warehouse on top of the hill is going to be done while the stream is being relocated.
There's a sufficient amount of earth moving that has to happen. So the final step is in the construction is going to be the building itself. So there's a lot else that has to go on there. So as the stream is being built, they'll be constructing the one basin that's in the city of Easton furthest to the east. That basin is also serving as a sediment basin. So that basin has to be built early on in the process to handle any of the dirty water while they're moving the dirt around and it rains. So that basin is intended to handle that.
And how would some of that earth moving that you're talking about early in the construction process affect the flows or affect the as-built nature of the proposed relocated stream?
So that's why it's in our construction sequence early, is to get that flows separated from the rest of where they're going to be moving earth and dirt on the site.
But if FEMA rejects the as-built as not exactly as proposed, it's a complete remodeling possibility based on the earth movement that's happened at that point.
It's a little bit too out in the future, but
If it's speculative, you can tell me it's speculative.
it's very speculative.
Okay, but it's not out of the range of possibility.
No.
That's all I have. Thank you.
That raised one question in my mind. Earlier in your testimony, I believe you indicated that, I think you said it was DEP was supportive of you daylighting the tributary because you were removing it from the pipe, which is presently surrounded by contaminated soil. So obviously then, I shouldn't say obviously, I presume.
I'm gonna, we did not say it's surrounded by contaminated.
I did mention that there's
yes, he did.
contaminated soils in the area,
Yes,
and I
he
did
did.
mention
I
that
apologize.
Mr. Smith would get to that testimony specifically.
Okay. I presume that tunnel is to be removed then, and I'm wondering what happens to that contaminated soil and why that contaminated soil exists and wasn't part of an environmental cleanup to this point.
I had to pick one to go first. Do me a favor, I'll have Jeff Smith get up and talk all about that.
Okay.
He's our environmental
Okay.
consultant. And he's basically going to tell you he's going to keep it all separate, but you're entitled to hear him.
Okay. You got to remember till next hearing because I don't even know if we're going to get to you tonight. All right, I'll hold that until.
Anyone else?
Mr. Haas, do I need to identify myself again? Mr. Haas, you had testified that that the methodology that was used to estimate the flow rates was consistent with engineering practices, correct?
Correct.
What was the methodology that was used to estimate the flow rates?
So we got our hydrology data from USGS STIR. The latest date from that information is 2019, I believe.
Did you use StreamStats to?
But we also use StreamStats. That's one of the first things we go to.
Mhm. And that was part of the methodology used to estimate the flow rates, correct?
Correct.
Did you use an area ratio analysis also?
You're really getting into the details of the report.
You're here to testify.
yeah,
You said
yeah.
you were familiar with the methodology.
Do not think we use that specifically on this one.
You don't believe you used an area ratio analysis to estimate the flow rates here?
We estimate the flow rates based on the data we get from StreamStats, from the USGS STIR, and then we use the standard modeling practice on our site for our stormwater basins, which is, we didn't use the rational method on this one, we used the SCS methodology, TRM, or TR55, for the stormwater analysis, and that gives us our proposed conditions flows.
Right, and that's important because some of the permits that you have received are contingent upon you not increasing the rate of flow from existing conditions, correct?
Correct.
And existing conditions that we're talking about when we talk about the estimates of the flow rates, correct?
Correct.
And so if the estimates of the flow rates of existing conditions are estimated to be too low or too high, that has implications with regard to your permits, correct?
I'm going to object. It's calling for speculation.
That's the methodology that was used.
The methodology for the existing conditions is part of what is reviewed to be compliant with the ordinance, in this case by Wilson Boroughs, City of Easton, LVPC, and DEP.
Mhm. And soil classification is also part of the methodology used to estimate flow rates, correct?
Correct.
And what was the soil classification you used for, and we keep on calling it, let me just, for a second, you keep on calling it an unnamed tributary. Have any of the maps, have you seen an actual name for this stream?
There is a name that's referred to more historically, but we go by GNIS, which does not have a name established to this.
And what is the name that you see on some of the maps for this stream?
I can't recall at the moment.
Spring Brook, correct?
That sounds familiar.
And so why is the soil classification important with regard to Spring Brook in terms of estimating the flow rates?
Is important for any project with earth disturbance and stormwater modeling. Soil classification type A would be a really absorbent soil. You typically find that more in, I want to say, New Jersey with sandy soils. You can find some in PA. Most of PA you'll find B and C, which are a little bit more typical. They don't absorb as much stormwater, so existing conditions would have more stormwater runoff. It also gets into proposed conditions. And type D soils is what you usually find adjacent to streams and in conditions where clayey soils, it doesn't absorb as much water. There's more runoff from type D soils.
And what was the classification used for the modeling here?
I cannot recall that off the top of my head because there's multiple soils across the site. And what we do is we aggregate the soils, and in some conditions, depends on how the reviewer likes to see it, we do defer to the reviewer. Do we break it apart and model each specific area based on each specific soil type? If there's type B here, type C there. And then there are some reviewers who will just say, you have about 50% type B, 50% type D, and just average it and use type C. So it's a complicated question, and we usually defer to the reviewer how they want us to do that modeling.
And you don't know, as you stand here today, what the classification for Springbrook or the stream we're talking
The
about
stream
is.
itself, I would expect to have a classification of D because it is a flowing water and it's not absorbent soil.
Have you done any studies in other areas of either the Bushkill Creek or the unnamed tributary Springbrook with regard to this?
I'm going to object. This is getting far afield from what he
This
testified.
is
I don't think it is.
What other, outside of this project?
As a result of this project, did you look at exactly what the soil classification was for different areas of this tributary, Springbrook, or the Bushkill Creek itself?
We typically don't look at the soils in a stream as far as soil classification of the stream itself.
And so, with regard to the soil classification here, you believe it was D, or you think it might have been D, but you're not sure.
Off the top of my head, I couldn't say because there are multiple across the site.
And with regard to the basins that you were instrumental in the design of, will the basins that's as designed reduce the volume of runoff in a 10-year storm?
10-year storm? No. The volume of runoff is separate from the rate.
Right. Will the basins reduce the volume of runoff in a 20-year storm?
Is again separate from the rate, which is what the ordinance requires.
Correct. And so, will the basins reduce the volume of runoff in a 100-year storm?
No.
That's all the question I have.
Thank you.
Bless you.
Anyone else? Here you. Oh, wait, we have one. You have to give your name, address for the record, and speak into the mic, please.
Kimberly Wagner from College Hill,
No, address, your address, please.
721 Cattell Street.
Thank
you. Exhibit A5 in your book. It's from the Joint Sewer Authority.
I'm sorry, I was
I don't have
otherwise
that as
engaged.
A5.
Can you repeat the question?
The Joint Sewer Authority that you're putting up there. Can you pull that?
My A5 is an overall plan,
I can see. I saw it up there, 2 down from that. The
2 down from A5. Plan of relocation.
1 more down.
Eastern area, chapter 94 consistency, yes.
There's a letter in there from Stan Margle dated February of 2025 that gave you a waiver for that from Wilson Borough
For the sewer?
for the sewer.
Yes.
We didn't give you the waiver, like you're saying that you have that permit, but under our ordinance, it's specifically required, and it says that you're not allowed to have an exemption for it.
So,
There's no question before you. We've gone through this with this witness, with this person before, and they just keep throwing up stuff. So if there's a question, ask the question, please.
Did you receive a waiver from the city of Easton for this?
Objection. There's no facts and evidence that says we need a waiver.
I'm sorry, waiver with respect to what?
They don't have that, like, they got a waiver from Wilson Borough for this permit here. They don't, and it's specifically required under our ordinance, and it says that it's not allowed to be exempt.
Objection, hearsay.
Well, can you, first of all, I'm not certain what waiver you're talking about. I don't mean to be dense.
You have to pull up the
Maybe just
letter
a
that you
late
received
hour,
from
but-
Stan Margle.
A waiver of what, ma'am?
There's a letter from Stan Margle in his display that he had up
Okay,
earlier.
but what is it waived that is required and cannot be waived by our ordinance?
That paper that he's putting up there, he's saying that is a permit, that he has that permit. And I'm just saying, No, it's something different. This was extra added. They have it in their book. If you give me 1 second.
I'm sorry, but your question has not yet.
It's under our checklist number 10. And it also says that that you will need to have the IPP permit. And the IPP permit,
Objection.
What section of of our ordinance are you referring to?
I just shuffled my papers around, so let me look. I have it in here.
Yeah, and I still haven't gotten an answer from you, ma'am, with respect to what was
There's
waived?
a whole module. So if anybody actually reads what that letter says, if it's read, they put a lot of things up there that they say one thing, but all of those letters actually say something else.
Objection.
So when that's up there, it says, this is not approval for, this is only capacity, like you have to read what that says. It says, note that this approval is only for capacity in the authority's conveyance system. Also note that we do not make any planning modules related to the PADEP. There's an extra planning module that's a requirement in our ordinance that this letter is saying that they're saying that they have all of this. The Joint Sewer Authority, the letter there clearly says that they do not have it.
I'm
There's
going to
a letter-
object to this mischaracterization.
It's not a mischaracterization.
We testified that this was the document that we got. We didn't characterize it.
It's not a permit and it's not an approval.
So, all right. Do you have a question of this witness? Because you'll be permitted to make a statement or give testimony later on,
Okay.
but I'm still not sure what question it is you're asking of this witness. And I don't think the witness is either, respectfully.
I don't know how to ask the question when my question is that do they have the appropriate DEP planning module for land development? But they
Well,
don't.
we're not here for land development, but do you have
It's
the required planning module?
Yes. So Wilson waived it because the sewer exits from Wilson and is not treated by any Wilson facilities.
Okay.
So we obtained that letter to show to DEP that Wilson is saying we're not involved in this. The sewer we're connecting to is actually owned by Forks Township. They were involved with it because it's the Easton Area Joint Sewer Authority. So we have Forks Township. We did coordinate with the city of Easton, and we did submit a planning module mailer to DEP, and they returned it as a waiver of a planning module is not necessary. You only get into the planning module specifically is if there is some sort of issue at the sewer plant, and the sewer plant is under some sort of DEP purview. They're analyzing it. They have too much nitrates, or if we're having some sort of on-site treatment that would affect it. Since the
Let me interrupt. Is this module with respect to sewage
yes,
related to these improvements that we're here
No.
for tonight, or the building?
it's related to the building and land development.
Is the sewage line going through the floodplain or is
No.
it showing?
We-
It
I provided testimony earlier that the existing sewer line is in the floodplain that is owned by Forks Township as it runs along the Bushkill Creek. We specifically selected a location that is outside the floodplain for our connection to the sewer line. Approximately, if I can do another little draw on here, in this area here, where the sewer line comes out of the Bushkill Creek's floodplain.
yeah, in the floodplain, like
The sewer line goes in and out of the floodplain because the floodplain is not a linear as the sewer line is. We chose a connection point outside of the floodplain so there would be no floodplain issues for our sewer line.
I presume no other questions, ma'am? Anyone else with questions of what this witness testified to?
Counselor, you want to call your next witness?
Yes, sir.
Oh, I think it's the same one. Okay. What? Just as long as yours is the last one. Okay, good. I don't need this now.
Would you identify yourself?
Yeah, my name's Jeffrey Smith. I'm a professional geologist.
Yeah, can you pull the mic just a little bit higher so everybody can hear you out in the hallway?
Hi, I'm Jeffrey Smith, professional geologist in Pennsylvania and Delaware.
I'm sorry, professional what?
Geologist.
Geologist?
And tell us about, what's your business address?
It's 1818 Market Street, Philadelphia, Pennsylvania.
And can we have Exhibit A15? Is A15 up on the board your curriculum vitae?
Yes, it is.
And is it an accurate representation of your education and experience?
Yes.
Jeff, I would like you to spend a couple of minutes and explain who you are and what you do and what your experience is, and of course who you work for.
Sure. First, I work for Langen Engineering and Environmental Services, LLC. I'm in the environmental practice area of that firm. We're a multidiscipline engineering firm. My primary duties involve a lot of diverse things, from business management, staff management, corporate initiatives and business development and technical training, as well as science of hydrogeology and contaminant fate and transport and cleanup.
Tell us about your professional experience.
I have 37 years experience as an environmental consultant, 27 of those with Langen. My experience is pretty diverse, from fundamental environmental phase 1 due diligence up through and including complicated environmental cleanups, remediation design, remedial construction, and litigation support.
And our particular focus here tonight, Jeff, is a brownfields cleanup, correct?
That's correct.
And this particular property spanned both the DEP purview and the EPA purview.
That is correct.
And you're going to get into that in a little while later.
Yes.
Have you ever testified as a witness before municipal boards or bodies, or really courts, or any place where you would have been questioned as to whether or not you're an expert?
Yeah, ironically, typically I don't find myself in this setting testifying. I have done it before, one time in Upper Makefield Township. It was in context of a residential development that was supported by a groundwater supply, and I was testifying on behalf of the viability of the groundwater supply for that development.
What about courts or other?
I've been involved in various capacities as an expert witness in private matters, litigation disputes under federal Superfund law. I've testified in federal court, testified in district court over disputes between private parties in terms of responsibilities and costs of cleanups. I've also testified against the Environmental Hearing Board and Pennsylvania DEP over a private party dispute about responsibility for contamination.
And have you been accepted in those proceedings as an expert?
I have.
I'd offer Mr. Smith as an expert in environmental engineering, geology, brownfields, investigation and remediation.
If I may, I want to clarify, I'm not an engineer by training, but I have a lot of coursework related to engineering, and I work closely with engineers.
Any questions? Any objections? Mr. Chairman?
So noted. Proceed.
Thank you. Are you generally familiar with the property it is the subject of tonight's special exception hearing? With some degree of detail, will you tell us what you were engaged to do with regard to this project that is the subject matter of this hearing?
Yeah, we were initially retained by our client in this matter to conduct environmental due diligence. They were contemplating purchase of this property for potential reuse. Going into it, there was known contamination concerns. Has a history of operations that date back to 1846. So we basically performed extensive environmental due diligence, first and foremost, to establish what are the history of uses and operations at the property, what are the potentials for contaminants to impact the environment, what has been done historically in terms of environmental investigation and response actions that had already taken place and occurred. When we took over this role for our client, the site was inactive, was not operating. It was undergoing later stages of decommissioning and eventually demolition of existing facilities. With that information, we produced reports and identified areas of concern or potential concern that warranted further investigation, and then eventually took that information, developed an approach to an investigation that eventually led to a remedial investigation and a cleanup plan under the Pennsylvania Act II voluntary cleanup program.
So, help me, how did I understand how DEP got involved? How did EPA and RCRA get involved?
So historically, 1976, RCRA, which is the Resource Conservation and Recovery Act, it's a federal regulation that is directed by EPA. It is basically related to storage, handling, and disposal of hazardous waste on facilities. This site at one point in time was subject to those regulations and associated what is called corrective action, which is another term for cleanup under RCRA.
So this site had a long history under RCRA.
Well, it depends on long, right?
I'm sorry, but
1976, RCRA was enacted. Since that time, it was regulated by RCRA. It still technically is, although a lot of its activities, when it was being regulated, have since been no longer regulated by RCRA. There's been a change in how they looked at certain things that were being done there. Nonetheless, it's still under RCRA, still requires final EPA approval.
Okay, and what I believe you said was that as a result of your investigation, you ultimately came up with an investigation and proposed cleanup plan under Pennsylvania's Voluntary Act II, correct?
That's correct. If I could supplement that answer, because of EPA's role and the RCRA applicability to the site, there is in Pennsylvania a memorandum of agreement that's between Pennsylvania DEP and EPA that is a collaborative effort to conduct cleanups. If you follow the state program for voluntary cleanup in Pennsylvania, EPA will go along with what's being done. They have participation in a collaborative process with DEP in that cleanup, and they eventually will also approve and adopt the cleanup unless they have specific requests for additional information.
Okay, so before we get down into the nitty-gritty and what you did, I think it would be very helpful and important here and on the board for you to explain Pennsylvania's land recycling program and environmental remediation standards Act 2 as we've called it.
Yeah, we refer to that as Act 2, so that's how I'll refer to it. It is and was established in 1995 in Pennsylvania. It is the standard voluntary cleanup program and has a long list of technical requirements and technical guidance that are associated with it. There is a set of multiple cleanup standards that you can apply to cleanups, and there is public notice requirements as well as a whole administrative process of how you go through that cleanup with Pennsylvania DEP.
When you said it is the standard, in my way of thinking, it is the gold standard of state cleanup programs.
It was, since 1995, at that time, was held up nationally as a model program for the country. It is a very flexible cleanup program in the sense that it is risk-based, so it gives you some flexibility to decide what is an appropriate level of cleanup that doesn't pose a risk to human health and the environment. And a big factor in that decision-making is a lot of science and engineering, but ultimately it depends on end use and how the property is going to be used.
And before this act, this is not a question, it's a statement, you'll tell me whether you agree, it was next to impossible in Pennsylvania to clean up a contaminated property, because once you owned it, you were responsible.
Yeah, I'm a scientist, so nothing's impossible, but it was very frustrating because you were essentially being required to clean up the conditions that existed sometimes naturally and sometimes in background due to other factors, and it was sometimes seemingly not practical, virtually impossible.
So you go through the process that you're going to explain, and we're going to show some drawings, but it's voluntary on the part of a property owner. And if the property owner does the right things that you're going to tell us about and gets an approved cleanup plan, approved by DEP, and then implements that plan, that landowner gets a release from liability, meaning that the state is not going to come after him and federal government's not going to come after him and say that you got a contaminated property, you got to clean it up.
That's right. It's one of the incentives of that voluntary program, yes.
Okay. Could you identify document 16? We're going to put it up.
Should be okay. I just use down arrows or mousepad.
So tell us what this, really, it's a PDF form, it's a program that you're going to take a couple of minutes and walk everybody through the Act 2 plan and what you've done here. Is that correct?
Yeah, if I may just sort of set up
Please.
where this comes from. So in the Pennsylvania Act 2 program, as I said, there's a public participation element of it. In particular, as is the case here, we weren't striving to achieve what's called the statewide health standards in Pennsylvania, which are standard risk-based numeric values that are lookup values in tables for the host of contaminants of concern in multiple media, soil, groundwater, and other. And you can compare your characterization results for the media that you sample to those statewide health risk-based numbers. That's one option under the program. If you don't meet those numbers or you can't reasonably achieve those numbers, there is the ability to apply risk-based approach to cleaning up the site. And that risk-based approach, as I alluded to earlier, is based on a lot of site-specific factors. And in this case, where there's a redevelopment of a brownfield site, that redevelopment is an integral part of a cleanup. Often, and very many times, can actually substantially achieve cleanup by simply doing the redevelopment in a responsible manner, following certain guidelines and things.
That's very important because there are a lot of people, and you've been with me, who have voiced their concern that when you do this, when we do the development, we're gonna reinfect or pollute or whatever, particularly the waters that we're talking about, that Don was talking about. You've been with me, you've heard that expressed.
Yes.
So, okay, with that in mind, would you walk us through your program?
Yeah, and I might go over things quickly in some aspects. I might focus on certain parts of this that I think are really relevant. We are running close to getting to the end of this, so I don't want to hold us up. But if people want to stop or look at certain things, let me know. The last thing I'll say is, as part of the public participation process, you have to file a notice of intent to remediate that gets published in a legal notice in the newspaper, and the public's made aware that, hey, this site is entering that cleanup program. There's a 30-day comment period. So that's started this process. The last thing I'll say is that excerpts of this presentation were something I do as sort of a standard practice of my own, is before we submit a report to an agency to review, in Pennsylvania Voluntary Cleanup Program, even with EPA, we'd like to walk them through this kind of a presentation to tell them what we did, what we found, what's the basis for what we did, and what's the implications of what we found with respect to the cleanup. So a lot of this was done in a presentation before we submitted a report to either agency. It was done in June 2024. The report was actually submitted September of 2024. We know the background, the history. I won't spend time here. I just want to mention 1876 is when operations initiated and commenced at the property. Essentially, over time, this was really used for synthetic and natural iron oxides and pigments. That's primarily what they did here. We mentioned EPA's involvement in RCRA, and that I also mentioned the collaboration and the agreement between Pennsylvania DEP and EPA under this one cleanup program. There's various aspects of this that I don't want to get into for the sake of time here, but it's basically a collaborative process where both agencies are reviewing things that we prepare simultaneously. At some point, there is sometimes a departure for how EPA views things versus DEP views things specifically, and most commonly with respect to groundwater. And I can touch on that in a little bit. I mentioned there's a lot of environmental history here in terms of previous investigations and previous response actions. I won't read through all of these. This is just a list, a selective list of summary of documents that we obtained and reviewed that really speak to the history of investigation, regulatory interaction and involvement, and some response actions to remove and close out things like underground storage tanks, above ground storage tanks, which were associated with this facility, as well as wastewater treatment plant closures. There was a release that was remediated under the Pennsylvania Cleanup Program by another party back in 2005. That was an element of what we reviewed. So we had a pretty exhaustive review of information. This is going to be hard to see. Part of our due diligence is we got to collect all the available information we have at our disposal to really understand what went on here. This list of things that are highlighted in green, there are areas of concern 1 through 15. Is a summary of what we ultimately decided from our review of all the historical information and documents. What are the areas of concern associated with historical operations here? And then we evaluate what to do about them and what level of investigation is needed and potentially cleanup is needed. This is just a summary of areas of concern shown in green, and then the list of things in the legend on the left are monitoring wells either that we installed or that were historically installed by others when there was a release of petroleum that was cleaned up under different time frame with Pennsylvania. Previous investigations of sampling of soil and other things that were done. So we were building a database of information that drove and led us to design what was an appropriate additional characterization to get to a decision point where we could decide what needs to be done to clean up the site. I mentioned the importance of the redevelopment plan in this context of being integrated as a critical element of the cleanup. Particularly here, as we know, the areas in red and orange are cuts, substantial cuts that are going to occur on this property. Fortunately here, the cuts are essentially in the hillside and mostly going to be rock and weathered rock materials. Removed from where most of the historical operations occurred, where most of the area of concerns resided. I said most, I didn't say all. So that material is going to be cut from areas that don't have areas of concern or don't have data historically or generated by us that represent impacts. The areas in green, where most of the operational areas and areas of concern do reside, fortunately in this circumstance, is going to be placed fill and substantial amounts of fill. In many cases, tens of feet of fill placed on top of where residual contamination, as we found from our characterization, may exist or does exist. The other aspect of this is that in terms of what we identified from the characterization, the metals and a very select list of metals are the primary constituents concerned. We don't have volatile organics, and we don't have other semi-volatiles or other contaminants that are more challenging and more problematic from an environmental cleanup standpoint. So we're talking about metals here. One thing I'll note, PFAS, it's everybody's topic of today. We did do research to identify whether any processes here may have contained PFAS. There's a whole variety of things and databases and sources of information that we tap into to evaluate that. It included incidents of fires, and we did identify one documented incident of a fire that was fought by placing firefighting foam to fight the fire. So we identified as an area of concern to investigate at the location where the foam was applied. We conducted soil sampling, analyzed for these 3 PFAS compounds that are listed here, and fortunately didn't find any in the soils as residual from when they fought that fire that exceed Pennsylvania's cleanup standards for PFAS. We looked at soils. We did over 20 soil borings, at least 2 samples per boring, analyzed them for a full suite of potential contaminants. We investigated groundwater. As I said, there was a previous investigation of groundwater that was cleaned up from a release that happened historically. We did 4 rounds of sampling from 7 monitoring wells that we installed across the property. And again, analyzed for a full suite of contaminants. What we were left with really is a select list of metals as the concerns that we found in groundwater. So because we didn't meet, one other thing I should mention is the standards that are applied in Pennsylvania have a category of standards for residential use and a category of standards for non-residential use. We were looking at non-residential standards. We did have a few instances where the data we collected showed the concentrations of certain contaminants, metals, did exceed the non-residential standards. So immediately kicks us into a site-specific approach where we have to do a site-specific risk assessment that looks at different factors that go into assessing and evaluating potential risks to human health, and also in this case to ecological environments, because we did sample surface water and sediment as well.
Wait, because you did what?
We sampled surface water and sediment as well. and that's in the unnamed tributary, the brook, and Bushkill Creek. And we applied EPA guidance, which is standard guidance in our industry, to do a risk assessment based on the certain site-specific factors and the data. So as I said, the outcome of the risk assessment was we looked at trespassers, we looked at industrial site workers, and we looked at construction workers. And even through the risk assessment process, there's a need to implement certain health and safety measures, controls, mainly dust controls, and maybe wear gloves and things to prevent direct contact in certain instances. But they will be written into the final cleanup of this site as what are called institutional controls. So they will be recorded as part of an environmental covenant that will be established for this property, for this site, at the end of the cleanup, and will also be used to govern health and safety practices for workers while they're doing the construction, so that any potential residual risk that may exist is going to be controlled and mitigated, both during the construction and then the cleanup itself will ensure that it has been mitigated, that there is no chance of exposure.
Say that again. That's maybe the most important thing that the
Yeah,
people here.
the cleanup's going to rely on the fact that there's all this fill that's being placed in and around the areas where the contamination does reside, albeit it's metals. And it's going to ensure that they remain in place, and that if there's any construction, which in this case probably won't encounter anything because the fill is going to be greater than 10 feet for the most part in the areas where the contamination is, it's going to remain there. The other part of the environmental covenant is from a groundwater perspective. There will be no use of groundwater on site. It's going to be restricted. And there are no off-site receptors that are threatened by the metals that exist in the groundwater on the
There's
site.
no well for a public water source.
Not downgraded or near enough to the site to be a concern.
So you've got metals here. I've been involved in a number of them. So you've got metals there that it doesn't make practical sense to remove them. However, based on all that you've gone through, you can redevelop this site, build a building on top of it, have employees there, and them not be exposed to those contaminants, whatever they are.
That is correct. I will tell you that is in every place that I am, even with certain clients who don't understand this concept, it's hard to accept, and I can appreciate that. It's standard practice in Pennsylvania in the cleanup program in Pennsylvania.
Absolutely standard. I did 3 Walmarts like that.
And it's scientifically based. I'm a licensed professional. I have to be responsible about what I do. So it's not taken lightly. If there is a potential risk or threat of a risk, it's not acceptable, right?
So could you, I know we've got a number of things we prepared, but I think this is dead on. I think that the other thing that I would like you to explain to everybody, as I understand it, there's a huge drop in elevation on this property. And in order to build a 1 million square foot building, you got to build a billiard table or a bowling alley or whatever. So you've got to cut from one place and fill from another.
Yeah.
So what questions that you and I have heard is, okay, it's great what Don's doing down there, taking the water out of a pipe. But how are we to know that when you do this remediation plan, which is tied together with Skinnell's redevelopment plan, it's going to be safe? And you can't see it when you look at that one-dimensional drawing that we have up there. So I would ask you, whichever drawing you want Jessica to put up, we'll put up, and try to explain everybody in this room how you're going to pull this off accomplish this, excuse me.
Well, I was gonna interject, and if you allow me, just talk about agency approvals for this. This isn't just Jeff Smith and Langing and our plan. This is a plan that was subject to Pennsylvania DEP's review, EPA's review. Pennsylvania DEP approved this plan in December of 2024. EPA has not fully approved everything because I mentioned to you before, under their record corrective action process, there is a departure in how Pennsylvania DEP and EPA look at groundwater. What I said is the remedy for groundwater under the voluntary cleanup program is restrict the use of groundwater on site, make sure that nobody off-site is potentially affected by potential migration of groundwater, document that. Pennsylvania accepts that. EPA doesn't, because EPA sticks to their guns of trying to restore all the groundwater to its original beneficial use, which means clean it up to clean, like pristine clean. So there's a process under record corrective action that we still have to go through with EPA to get to the end point, which is a final decision from EPA. And it's really just more monitoring of groundwater, more demonstration of what we've already demonstrated. And at the end of the day, it will lead to a decision by EPA. It's just going to take more time. And I have many examples under this one cleanup program where that's the case.
But there's not going to be anything moved, no dirt moved, no construction until that's satisfied, or is there some bifurcation?
Yeah, I don't want to predict what EPA might say ultimately, and not having data to fully demonstrate the case that we have to make. I don't want to say that prematurely, but that is the goal. But if there is a need, for instance, there's an area of soil that EPA says, you know what, that concentration of arsenic, let's just pick an example, is high, and it's not in an area of substantial fill. That's a threat of an ongoing source to groundwater. We need to do something else there. Like maybe we dig it out, just as an example. So who knows? Until we get the data, I don't want to speculate about where that goes, but that is our expectation. It's consistent with what we've done elsewhere when EPA's been involved on these kinds of sites.
But I'm sorry, I didn't articulate it. So the people in this room are going to say, well, before you get the EPA approval, are you going to start this cleanup? I don't believe our client will start this cleanup or remediation until both of those approvals are in place.
Except that EPA has weighed in on their opinion about the cleanup plan with respect to soil. They have written a letter, I think it's in the documents you may have shared today, where EPA has weighed in and said, we reviewed the cleanup plan, we haven't given you final approval, but with respect to what we're doing about soils and the planned reuse and conceptual at that time redevelopment plan, they see no concerns with how we're managing the soil cleanup consistent with the cleanup plan.
And that would get us a total approval under Act 2, and under Act 2, there would be a covenant that said no groundwater being used here.
Yeah.
So whether it's clean to umpteenth degree or it's clean a little bit less, there will be no pathway to contamination from that groundwater to people who will be working in that plant.
A technical term that we apply to these kinds of cleanups is we eliminate the exposure pathway. So to the extent there is a pathway of exposure today, what we're doing as part of this cleanup plan will eliminate that potential pathway of exposure.
So
Pathway of sorry. It'll eliminate the potential pathway of exposure.
So, Jeff, I started to say this before. Is there a drawing that you could use, or can you use this drawing to demonstrate how the cleanup will be done, how the dirt will be moved around, to give people a level of comfort that that program or that redevelopment is not going to make this worse? Or
yeah, I'll try to talk through it. So as I said,
You have to talk into the microphone now. I'm sorry.
well, I can't see the figure, but I'll do my best. Let me try this. I don't think I have that slide, but it's okay. I'll talk to it. Again, this drawing represents in the different color shades what I refer to as the cut and fill plan for the redevelopment. Areas in red and yellow represent areas where material is going to be cut. So the existing soil rock on the site is being cut. Deep red means deeper cuts. Yellow is less deep cuts. The green areas represent fill, and the denser green, or starting to become blue, is greater thicknesses of fill. And as we know, the area to the south, let's say the central area where the deepest blue fill is being depicted. That's roughly where you can see where the stream, existing tributary, runs. That's in an area of substantial fill for the most part, except for this lower reach that's down here at the end. That area, I think we said, Mr. Haas said, we don't know what's in that channel, frankly, the culverted or piped channel. We didn't sample anything inside that. We sampled all the areas around it, and we have samples from sediment and surface water within that tributary. So that was part of what we characterized. What's inside that channel, we don't know. So that may be handled differently, may be managed from a standpoint of removing it with the concrete and the structures associated with that and disposing it. That might be part of this. It's not something that we contemplated for what we're doing from a cleanup standpoint. But because that area is going to be filled, and that's an area where the metals, the remaining contaminants of concern, reside in soil, that cover of that placed fill is going to provide the protection to mitigate the potential exposure risk that we're talking about. With respect to the topic of today, the relocated channel, you see that's in the area below. That's a cut, and also where the basin is. So material is going to be removed there, but there's no known contamination in the footprint of where that relocation channel is going. So again, we're taking it out from an area that's artificially conveyed at the site, associated with surrounding soils that we know have metals contamination. That's a potential concern. We're filling over that, and we're going to move that channel to a place that doesn't have those conditions. So it's, in my opinion, from the standpoint of what we know about the site, what we characterized, and what the differences are between the existing conditions and the new conditions, the new conditions will be an improvement for that waterway.
Could we turn back to the exhibits? There's 3 or 4 exhibits at the end here in my book that I haven't had you identify. I did have you identify your PDF, the program you just put on.
Yeah.
And would you look at document 17 and tell us what it is? I think it's called a receipt of notice of intent to remediate. Could you tell us briefly what that is?
Yeah, that's dated March 22nd, 2024. It's Pennsylvania's DEP acknowledgement that they received our notice of intent to remediate. On behalf of our client, we submitted a notice of intent to remediate as part of the Act 2 voluntary cleanup program. That is your entry into the program, that notice of intent.
And they're attached to this publications in local newspapers and I guess the Pennsylvania Bulletin.
Yes.
Complying with all the notice requirements.
Correct.
Let's go to the next document. And this is a document dated September 26, 2024. And this just looks like a receipt of a report. So could you tell us what this is?
Yeah, I think I mentioned previously, we, in September 2024, submitted what is called a remedial investigation, risk assessment, and cleanup plan report to Pennsylvania DEP.
And number 19. Looks like a set. Oh, this is your report, is it not?
That is our report, correct?
And this is a combined remedial investigation, risk assessment, and cleanup report.
Correct.
Just memorializes what you basically have told us.
In more detail, but yes.
And the last document, number 20, is the comfort letter, I believe, from EPA. Would you characterize that? Is that the letter that says, that you said before, that EPA said, we like your soil, but we're not ready to approve you yet?
That is correct. You used the term comfort letter. Traditionally, that was a thing that EPA coined, that phrase. They no longer like that phrase, but we still refer to it as that. It's basically their acknowledgement of an acceptance, not a formal approval, an acceptance of the idea of what we plan to do.
Well, representing developers, I was never sure how much comfort it gave me. I have no further questions for Mr. Smith.
Are there any questions for Mr. Smith from the board? Anybody out there? Do you have any questions for Mr. Smith?
I do. Mr. Smith, you said that you did soil borings, correct? Or soil samples? Or
Well-
both?
Well, borings to sample, yes.
Okay. And where were the soil borings that you did?
I can show you on the map.
That'd be great.
Yes, let's pull up the slide. Okay. No, actually, go. Yeah, that's good. No, something like that. I don't know. I'm just reviewing this because this may just show the borings that we had done, which are labeled LB, but I think if you want to start there.
Sure, I'm asking where were the soil borings done?
As I said, they're labeled LB, but at this scale, I don't think anybody in the room can probably see what they are, but they're black circles with labels next to them scattered across the site.
Were soil borings done in the area of Springbrook?
Yes.
And could you show us on the map where those soil borings were done?
We can follow Springbrook here, just across the site and up there, and you can see borings that are done along it on either side and to the north.
And to the north. So you've done soil borings both in the area of Springbrook as it exists and in the area where this would be intended to be moved, correct?
Right.
And you said that there were no contaminants in those samples, correct?
That was what I recalled, yes.
Yeah. Did you do subsurface investigation with regard to the area where the Springbrook is?
Soil borings were subsurface. I don't have the depths off the top of my head. They were drilled at least to the depth of groundwater, which is about 10 to 15 feet.
Okay.
In some instances, they were drilled for the purposes of installing monitoring wells, so they were deeper than that.
Okay. And so can you tell on the map how deep each of the soil borings in the area of the tributary were done?
On the map, no.
Okay.
I'd have to dig in my report. I don't have that knowledge in my head.
Is it in your report that you have submitted today? That's in the
It's in our-
binder?
It is in there.
Okay. And what is the underlying geology of the site in the area where Springbrook is?
It's pretty general question. What do you mean by underlying geology?
there
You're
limestone
talking about
in the area?
soils, you're talking about limestone, marble, what are you asking?
I'm asking about limestone. Is there limestone in the
Limestone
area?
and marble, yeah.
Okay. It's so underlying the area where the creek is, this tributary is, there would be limestone and marble underneath where the soil borings were done, correct?
In the soil borings that were
In the
done.
soil borings. Okay. Well, of course I have.
Yeah, 5 minutes.
Just a question. The outline on the map there, is that to indicate the warehouse? Is that what that represents?
I'm not saying it's the current one, it was a concept at the time. It may have shifted or rotated slightly, I don't remember which version that is.
Could you clarify, it may have shifted or it has shifted?
Mr. Haas could clarify better than me, I'm not the design
So-
engineer.
So it's safe to say that you're not confident that the warehouse outline represented on this study accurately represents the warehouse plan submitted before the zoning board and planning?
I'm confident that for what the cleanup is, it doesn't matter.
But could you answer the question? Does that represent
I did,
the way?
I did, I said I
No,
wasn't
no,
sure.
you-
I said I
you-
wasn't
you offered it.
sure about the
No.
outline of the building. I think I said that.
I would ask the solicitor to remind the witness to stick to answering the questions asked.
I object
think I
to your
answered.
characterization. I think he answered the question.
No, he said it doesn't matter.
No, I said
But
both.
the question I asked was, is it an accurate outline of where the warehouse as built is intended to go?
And I will answer as I have answered. I don't know with certainty.
Okay.
I don't know about the outline.
Can you please zoom up on the map so we can see the northern part of it? Okay. So now we can see that if I could also see in comparison applicant's exhibit A7, the map without topographical lines that we've been relying on.
What do you mean in comparison?
I would
can't-
just like you to
I
see
can't
that.
put two of them up.
Okay, well, we can remember, actually, I can solve this. Now, what we're presenting, just for demonstrative purposes, we're not trying to enter it in the exhibit, is the plan map dated, I think, April 2023, maybe. Hold on, I want to think of a good question here. Give me one moment.
Can the witness move away from so the board can see? Thank you.
Did you do any sampling in the northern part of the property that is where the Bushkill makes that turn southward? No, I think that's off the property, but off the property owned by the applicant.
Can you point out where you're asking me to look?
Did you do any sampling north of the area indicated on your map? Up here? North of.
North of what area?
LD
Can you
12.
point to the area that you're referencing?
You know what, I can't.
Can you point to the north area that you're referencing where you're asking me whether I did sampling?
I'm gonna ask a better question. Did you do any sampling north of the LB12 marker indicated on your sampling map?
I did not.
No further questions.
All right.
No further questions for the.
All right, thank you.
It's 10 o'clock.
Yeah.
Can I ask two questions in the 1 minute?
But
I will be under 9:15. Mr. Smith? Sure, it's Jeff Fleischaker, Fleischhaker.
You blew the 1 minute, Jeff.
Killing me. Mr. Smith, you indicated that even though the comfort letter was issued, there's a possibility that EPA could come back and say, we don't like something and we need to make a change. Is that right?
They acknowledged that the approach to soils as written in the cleanup plan was quote unquote acceptable, but it's not a final decision.
There's always a chance something could change.
Specifically, groundwater is the reason, as I mentioned, but
And
there
is-
could be a change.
Is there a possibility that in that change that EPA would request that the proposed location of the relocated tributary would have to get altered?
EPA has had no comment with regard to that topic.
But it's possible they could at some point.
I guess anything's possible.
Yeah, that's all. 9:58.
There's more than two, though. With that, folks, I would recommend to the board that we adjourn for the evening and save further public questioning of this before we make it necessary for him to come back. Is there anyone present who would like to ask questions of this gentleman relative to what he testified to? Two people. One maybe. All right. Then let's hold that. Ma'am? I'm sorry, we can't hear you. Okay. I didn't know if you were trying to say something or... Oh, yes. Oh, were you asking if he will be present for public comment? No, that's what public comment is, just that. It's not asking questions.
I think she wants to ask a question of the witness. She's not sure she's allowed to at this point.
Oh, no, that's why I'm asking if there are people who do want to ask him questions.
I think her hand should be raised in that regard.
Okay, all right, thank you for that assistance. So there are people who want to question this witness. We'll save it for next time. Mr. Tillman.
May I just ask a question?
Yes, sir.
Is it possible to limit the people who ask the question to the three people who have put up their hand now?
Ma'am, please. I understand what you're asking, and I really understand why. But I think it would be unfair to do that because the answers to certain questions may create other questions as a result of those answers. So I think it would be unfair to set that limit. That said, what I said at the opening of the hearing will stand. If the questions are irrelevant to what the board is hearing, they will be disallowed and disregarded. If there are repetitive questions, they will be disallowed and disregarded. Okay? Mr. Tillman,
Yes.
can you assume responsibility for, well, I guess I have all of council's emails, don't I?
I can make sure the board gets notified as well.
No, but I was wondering if you could assume responsibility for communicating with everybody to find another date, or do you need me to do that?
You could do it.
Okay.
We'll let you do it.
Oh,
We'll let you do it.
you're a pal. Sir?
I'm sure I'm going to bring my witnesses back. If people are going to get up and ask questions or make comments, unfortunately, I'll have to bring them back.
I believe it probably would be best in case there's any redirect necessary or or rebuttal. So for folks in the audience, there's going to be, well, the communication is going to be between myself and the attorneys involved to find, and obviously I'm going to communicate with my board members as far as their availability for an open date for a continued special hearing night. And, you know, between the six of us up here, well, seven, with Ms. Genova, and all counsel involved, it may take us a week, 10 days, hopefully, to come up with a new date. The new date will be posted, Mr. Tillman,
Yep.
on the zoning office.
It'll be posted everywhere. It'll be in the newspaper. We'll post in the newspaper as well, and it'll be on the city website at City of Easton's Facebook page. I mean, we'll get it out so everybody knows exactly what day it is in time.
Yeah.
As soon as I know, I'll get it out to the public. So, I mean, if Bob tells me tomorrow we have a day, I'm going to get it out the next day. So everybody's aware of what day it is.
I think what you're asking is how much notice are you going to be given?
Yeah.
I mean, I'm sorry, were you going to say
No, no.
something? Oh, just stretching. I know, we all want to do that. I believe that the date should go out at least a week to 10 days in advance. Okay?
We'll never get a date that quick. It's gonna be a while. So
No, but I'm saying when we have a date, announce it at least probably 2 weeks in advance,
Sure.
especially if we're going to re-advertise it, which I believe we have to do.
I
because we're
think
not
we're gonna
able
have to,
do it.
we're gonna have to
Yeah,
re-advertise.
we're not able to
Yeah.
set a date tonight, sir.
Will the documents that are made, that are in the book, you talked about, are they all assembled online electronically so the public can see those and go back and go through them?
I believe they're all on the portal.
I mean, not all over the place, but are they all in a
They're in the
precise
application.
spot
They're not online though for them to
Not
review.
Liz, not Liz.
where the public can go and look at all the exhibits that we're going through tonight?
Well,
The city's got a portal that you can get on, I believe.
Well, not everybody can get on it. It's the majority of the time the plans aren't provided to the public because they're engineered plans.
Jess, you've got everything on a thumb drive, don't you?
I can get it sent over to you.
Okay.
We'll send it over to you.
Okay, motion.
Is there a way for the public to access that? Understand the attorneys on this side are a little listen to information.
So what I'll do is once she gives me the information, I'll upload all the documents that she gives to me on the website. We'll have a link where everybody can get to it on the city website. Yep, you got it.
TK requests. All right, motion to adjourn.
Motion to it. Second.
Who motioned?
Mrs. Panto.
Who second?
Me.
All right,
Thank you, everyone.
on one.
Ms. Panto?
Aye.
Mr. Civitella?
Aye.
Mr. Lopsak?
Aye.
Ms. Stark? I mean, Miss Linda Thomas?
Aye. Then.
I will have to
Wait.
come in and share files.
I'm
not
one
some-
from the.
Oh, my
But I
gosh.
can come in and share a file for you.
I'm
I
exhausted.
think I have your email address.
And
Yeah.
if I sat through this tonight and I'm not gonna be here for the end of it, I'm gonna be here.
Of course, but I'll get them to you.
Right.
Oh,
I mean,
Email me what days you're not gonna be here, just so I have it.
yeah, I will.
Oh. You know what? Oh, I appreciate it. You know what?
Excuse me, can I have everybody's attention for a second? Can everybody just clean up anything that you brought or left lay on the floor? Because at the end of the day, I have to clean up once everybody leaves. I'd appreciate that. Thank you.